But maybe permit to mention my item number 72 of your lordship's combined list. 58 the lead matter. Issue involved in petition, my lord. We are the respondent writ petitioner. We got an order from this honorable court permitting my lord us to sit in the interview process. Now, my lord, what has happened? West Bengal Board of Primary Education preferred this appeal. In the meantime, the Honorable Supreme Court passed an order in respect of the recruitment process of 2022 that immediately conclude the recruitment process. The direction upon the West Bengal Board of Primary Education, then my lord, the petitioner.
What do you want?
Upgradation.
Matter was called on last month also.
No.
Last month the called on and my lord fixed
was
the matter
fixed.
on it will directly appear on 3rd November. And thereafter the my lord the urgency is the contempt matter. They in the contempt matter.
Who are you?
I am for the same footing on respondent in 58 matters, the lead matter, 58 matters. Monthly list of 58.
Monthly list 58, the lead matter, and I am my item number 72.
Analogous.
58 to 72 analogous.
Same. With
my lord, all hard.
That is a council appeal.
Yes.
Council's appeal.
West Bengal Board.
Have you given notice to board?
Yes, already.
Are you appearing?
No, I am for this respondent in lead.
No. Mr. Biswas.
Of the petitioners.
Immediately take
interview of the petitioners.
Very good. If you succeed, they will take.
In the meantime,
No, my lord,
if the recruitment process is concluded in terms of the order of the Supreme Court orders, then my lord, our right will be.
So come with an application annexing Supreme Court order if that is relevant to the issue. Come with an application. Tell us that this is the problem. That is why we want appropriate orders on this.
Okay.
But we were also.
I can file. Well, I can file an application in annexing the Supreme Court order, subsequently contempt order. We preferred an contempt before the Honorable Supreme
Court. You will be relying upon those orders.
Yes.
You are the respondent in the appeal. Yes. So in respect of the lead matter, you file an affidavit, say for expeditious hearing and annex the documents. Then once you serve it to Mr. Biswas, then we will take it upon a day.
And we shall mention the matter before your lordship.
After you file an ex,
yes.
I am not suggesting. I'm just thinking. You consider it's your matter. If you think that no such application is required, then you mention on Monday. We will fix it. And if you think that has to be brought on record,
yes. You have to bring the.
Consult the papers.
My lord, lordship may recall, my lord, this is a matter where my lord Justice Horish Tandon, when my lord was there, my lord, his lordship was pleased to my lord conclude the hearing. After that, my lord Justice Somen Sen, my lord conclude the matter.
The Supreme Court order has come.
Yes.
My lord, I believe, my lord, that is not related with.
Very good. You will get your chance to get it. You consider whether you will file an application because you will be relying upon that. I cannot advise you, and if you think that is not,
have to bring the order before your lordship's, my lord, by way of affidavit, whatever may be application. The subsequent order passed by the Honorable Supreme Court and the order passed in contempt jurisdiction.
Date fixed. Time period given?
No time, just immediate. No time has been given. Thereafter, we preferred an contempt petition. On 12th September, the Honorable Supreme Court stated that they have to conclude it by 6 weeks. That has not been complied with till date. Already, my lord,
দিয়ে দাও 19 তারিখ বলছো।
যদি পরের week এ পরের মাসে বলেন তাহলে
No, সুপ্রিম কোর্টের ডিরেকশন কি
তাহলে
আছে?
9
19th,
19th,
My lord,
58 to
72.
ask Mr. Sharma to.
Obligation, get.
may I have your lordship's kind leave, my lord, to mention, my lord, the contempt application, my lord. Yesterday, my lord, I mentioned the lordship was desirous that, my lord, I serve a notice and, my lord, come back and mention today.
20 তারিখ আচ্ছা ঠিক আছে হ্যাঁ।
My lord, a contempt application, my lord.
Our
My
determination,
lord, it was, my lord, the coordinate bench, my lord, where, my lord, Justice Velumoni was there.
fresh matter.
Not, my lord, fresh. This particular bench, my lord, had taken up this contempt once.
Then what happened? What?
My lord, there was a direction, my lord, for service upon the, my lord, alleged contemptors and, my lord, to file an affidavit of service. My lord, I'll be candid with your lordship. My lord, this is a changed brief. My lord, we have to ascertain whether, my lord, because, my lord, the instructions are the affidavit of service was filed, but we do not have it in our file. So, my lord, we will ascertain from the record. But, my lord, we have also served the, my lord, the concerned. Yesterday, my lord, I have annexed the notice that, my lord, we shall mention the matter tomorrow, today.
No, initial order was to serve upon the alleged contempt.
My lord, my lord, my lord.
Don't know whether that has been
My lord,
done or not.
My lord, from my lord, from my lord, this, my lord, instruction that is there, my lord, kindly give, my lord, I shall, my lord, ascertain in the meantime.
Yes.
I'm grateful, my lord.
My lord, directed on 10th of September to file a paper book, informal paper book. The petitioner is out of employment for the last 2 years. On 10th of September, my lord directed to file a informal paper book. Paper book is ready. So, my lord, kindly fix a date, then we can.
Is it in the list?
No, it's not in the list. My lord, give liberty given to mention the matter.
Because you give the slip একটা দিন দেখে নাও।
Lordship, may I permit to mention one review application, Lordship?
Review of our court's order.
No, Lordship, the review application, earlier order was passed by Honorable Justice Poti Prakash Banerjee and the Dipankar Datta, Lordship, Honorable Justice. And
This is group
this,
Group 2.
yes, Lordship.
Give this.
Your lordships, if I may be
Are
permitted
you
to
mentioning upon notice?
No, Lordship, earlier occasion, there is a specific direction, the matter should be appear on the month list of November. But in the November list, there is,
Who passed that order? We passed that
yes,
order.
Lordship.
It does not happen.
I have, there is a specific direction also that the notice should be served upon the respondent because there at
Very
the
good.
time.
It will appear in the next
I-
monthly list.
Great.
Yes.
Your lordship, if I may be permitted to mention two matters for inclusion, your lordships. The first matter is a group 2 matter.
Are you mentioning upon notice?
Yes, your lordship.
Group
It is
2 application?
yes, your lordship. No contempt application, your lordship. Where
Contempt of our order?
no, your lordship. Honorable Justice Dipankar Datta and Honorable Justice Poti Prakash Banerjee, your lordship.
Combined list, yes.
Lordship, I have another matter, your lordship. That is a MAT application where the appellant, your lordship, was a participant of the.
No, is it in application stage or hearing?
This is admission application, your lordship. The second
New
matter.
matter.
Yes, your lordship.
When did you file it?
Your lordship, the MAT was filed last month, I think.
Then it did not appear on the returnable
No,
date.
no, your lordship. I am mentioning. Your lordship, if you could just give me 2 minutes to
MAT application for inclusion in
just
And
hear.
over the slip it will appear.
I know, lordship, but if you could please kindly fix the matter, your lordship. There is
Sorry, let it
urgency.
appear first in the list.
I'll-
then.
I am
Your lordship, please kindly,
MAT
your
application
lordship.
for inclusion
the
in the list,
urgency-
lordship.
Madam, give this
Lordship,
slip.
the
We
matter
cannot
is
fix
petitioner.
it now. Have you served? Are you mentioning our notice?
This is an admission application, admission appeal, your lordship. The NEET examination that was conducted, your lordship. So if you could,
Your application was hard.
no, the MAT,
I didn't to mention.
the MAT application has, this is the first time, your lordship, the MAT has been.
দেখে নাও, দেখে নিয়ে লিস্টে তো
Lordship, there is one MAT application, lordship. I'm paying for inclusion in the list, lordship. Lordship, the matter is about petitioner has challenged one vacancy notification issued by.
What do you want? Application?
Yes, lordship.
Have you served? Mentioning our notice?
No, lordship.
Please give a notice and mention.
My lordship, may I permit to mention inclusion for application? This is a new matter.
When was it filed?
Next week.
Next week not has not come yet.
Sorry, previous.
Previous.
Sorry.
Yes.
Sorry.
My lord, application for contempt, my lord.
Contempt of
Well,
our order.
No, my lord, order was passed by the my lord, Honorable Justice Harish Tandon and Ravindra Sahab.
Combined list. Yes, all the list.
My lord, I am for the appellants, my lord. The last occasion, my lord, sir, your lordship sitting with Justice Mitro, my lord, directed the board to file a report. Although it has not gone down to the order, my lord, it is only adjourned for instructions.
Tell us what was the matter.
Yes, my lord. My lord,
That instruction has come.
these appellants, my lord, participated in 2022 selection process. My lord, these appellants are trained prior to 2022. My lord, by virtue of this honorable court's order, my lord, the pursuing DLED candidate of 2020 and 2022 batch was allowed to participate in the process. My lord, subsequently, by virtue of division bench order, their participation has been terminated. They preferred SLP before the Supreme Court. The Supreme Court initially by interim order dated 29th of January 2024 directed the board to conduct interview for the 2020-2022 DLED candidates, my lord. So their interview was also already over.
What was that page?
Let interview. Your lordship will find that order starting from page.
No, what did we said? We asked Mr. Shannan, your contention was just
My contention was
that in terms of Supreme Court order,
yes, the subsequent batch of DLED were allowed to participate in the process. Now, Supreme Court in the final order said that you complete the selection process as expeditiously as possible. So before the Supreme Court, we made application for intervention stating that the remaining vacancies should be filled up with us considering our candidature and the candidates of 2020-2022 DLED batch, my lord.
then you are of which batch?
I am prior 2020.
Prior to 20.
Yes, and they were the pursuing batch. When the interview notification came, they were pursuing their DLED.
Those the other branch.
Yes.
You have completed your
Yes.
DL.
Yes. My interview.
Your prayer in the writ petition was to publish a panel
Yes.
against remaining 2 and 3 as a part of recruitment notification 29 amongst the petitioners who are within unobserved list and the then what did ultimately the Supreme Court say?
The Supreme Court ultimately said that you conclude the selection process.
It's that page.
Yes, my lord, that page is at page 243 in my stay application.
243.
Yes.
Division bench judgment was set aside.
Yes.
What was the division bench judgment?
Division bench judgment directed the exclusion of pursuing candidates. 2020-2022
And what
DL.
was your order in your writ petition?
Well, I have never preferred any writ petition during participation of the selection process because I was allowed to participate.
No, this writ petition.
This writ petition is subsequent to Supreme Court's order because Supreme Court said in my intervention application.
So you were allowed to participate.
Yes.
Now
I was allowed.
What is your problem then now?
No, my lord, my problem is that the Supreme Court had said that remaining vacancies should be filled up expeditiously.
Show us.
Yes, my lord, the 243, my lord, paragraph 33. And operative part is at 244.
Notification date of 21st October does not tally with your prayer in the writ petition.
My lord, the initial notification is of 29th September, the first notification. Thereafter, in 21st October, my lord, they have stated the vacancy details.
I see.
The initial notification is of 29th September.
Acha, page, show us that, which page you said? 43.
244, my lord. Thereafter, paragraph.
Recruitment process must proceed further and the board must take immediate step for concluding the recruitment.
Yes. Thereafter,
And,
paragraph 34 is important for us, my lord.
Yes, place na.
Our consideration was confined to examine the legality and validity of the judgment and order passed by the division bench of the High Court. All applications for imprisonment are dismissed and withdrawn. The applicants are permitted to avail such remedies as are available to them in law. If remedies are invoked, their prayers will be considered and disposed of by the respective courts or tribunals on their own merits. Now, our prayer before my lords are,
So your implement applications were rejected,
yes, dismissed and withdrawn.
dismissed and withdrawn, and said that you will be at liberty to avail remedies. Then what did you do?
Right. Thereafter we have waited for some times. We preferred writ petition. We have prayed that the subsequent part of the panel must be published following the Supreme Court judgment. My lord, in the first hearing, my lord, in the month of May, the board submitted before the single bench, that we shall take instruction. In the second order, my lord, that is order impugned here, 17 June 2025, the board said that only 2020, 22, 22.
Where, page 17 June.
Yes, the order impugned here, my lord. I have annexed.
Page.
Memo de na.
It is not in your stay application.
But it is in memo at page 5.
You have not annexed there.
আচ্ছা দেবেন দেখা
254, my lord, page.
Just a moment. You are Ajmanul Islam.
Yes, madam.
Now, ultimately, page 258, Mr. Sannal said, so page 257, your contention was submitted petitioners in terms of Supreme Court order arising of such and such is required to consider candidature of those who were pursuing DALD for the course 22. Petitioners in the way completed prior to that, and they participated to him, but they did not come within the zone of consideration while giving appointment to similarly circumstanced other candidates while filling up 9533 posts. Then what happened?
Thereafter, my lord, in the subsequent order, my lord,
There are further vacancies.
yes, 2,500 and odd. My lord, total vacancies of 11,765.
So they prepared the panel in respect of
Yes,
9593.
they choose to prepare panel in respect of 9533, including 5%.
5% of?
5% of additional panel, my lord, according to the rules.
Acha. So now your prayer is you published the panel pertaining to the remaining vacancies.
Yes.
Now, Mr. Sannal wanted to take instruction. Then on the last date, what happened?
Yes, my last date, why I am coming before you, my lords, my lord, that needs to be till
No,
the
no,
court.
you have already been considered. You have come within the domain of the selection process.
Yes, as well as the
You did not
2020,
come within
2022.
You did not come within the first 9,500
Yes, yes,
vacancies.
that's true.
So the remaining vacancies, they will have to publish a panel.
Yes.
Now then, what is your grievance? What
My
do you-
grievance is in the remaining vacancies,
Huh.
my lord, the subsequent action by the board, that is page 261. What they did, my lord, in the remaining vacancies, my lord, they have filed an
One is a Supreme Court petition.
yes, they have filed a miscellaneous application before the Supreme Court, stating that the remaining
Connection with what?
in connection with the matter, my lord, where the pursuing candidates are allowed to participate in this process. Just now, I have shown your lordship the order, my lord, where we have preferred intervention application.
Acha, in the 2022 was allowed.
Yes,
Very good.
their interview has been concluded. Even our interview has been concluded. In the first set of panel, we did not feature. Now, our score is visible to all because they have submitted affidavit before the Supreme Court stating our score also. We are just shortfall to cut off, point something %. Now, so far the 2020 and 2022 DLED candidates, my lord, they are yet to publish the panel. They are yet to publish their merit score also. So our grievance before my lords are that if these remaining vacancies, 2,500 and odd vacancies, they need to fill up according to the Supreme Court judgment, they have to consider our candidature also. We are not praying for reconsideration because our interview is over. Now, if they secure less marks than us, because
it's automatic, Mr.
yes, no, but the subsequent action that to page 261, my lord, they filed this application before the Supreme Court saying that we are considering the candidature of 2020-22 to only. They are,
Wait.
yes.
Page 364.
Well, starting from page 261, well, I am showing the operative part.
61 is the
On the application, I have annexed the entire application filed by the board before the Supreme Court.
no, show us the relevant.
Yes, my
section.
lord, yes.
Page 264 is the order, na?
Yes, 264. The relevant part is at page 300. May I place before you, my lords, my lord?
Is the petition copy.
Yes,
What is the order?
order I have annexed.
They were directed to file an affidavit.
No, no, no.
364.
The Supreme Court said that within 6 months, within 6 weeks, you complete the selection process.
Where is that?
But at page 391.
Early implement. Pending applications including intervention shall also stand disposed of. Then a line is missing. Page 392.
No, well, that is all.
For
In
early-
view of this direction, the miscellaneous application and contempt petitions are disposed of.
What is the state is direct? What is for early
Yes,
implementation?
well, in this application,
Early implementation of which judgment?
the judgment passed by the Supreme Court
That is
allowing participation of 2020-2022 DLED candidates.
Acha. That is you showed us.
Yes, in that judgment,
140.
243, 244 operative part.
Very good.
Your Lordship, my Lord will find that in that judgment, Supreme Court has examined the legality and validity of their participation, not said that you issue appointment letter in their favor. But the action by the board by filing this miscellaneous application before the Supreme Court, my Lord, shows that they are intending to appoint only those candidates 2020, 2022, as if these vacancies are earmarked for 2020 and 2022 DLED candidates. So that is our grievance before your Lord.
But you were, but you are prior to 2020.
Yes.
So are they saying that you have been allowed to participate?
They are not saying before the court, they are not saying that we will allow only 2022, but their action, well, the application itself says that before the Supreme Court, because
so that day, now I remember, so we asked Mr.
Yes.
Signal to come with an instruction as to whether you will be considered or not.
Yes.
In respect of
yes,
those vacancies.
but they said that anyone who secure less marks than me will not be appointed. If that we have submitted that if they submit before your lordships that they will not consider anyone who secure less marks than me, then my case goes before the single bench also, because single bench directed to file affidavit, but they did not file their affidavit.
Yes, Mr. Vishwas, what is your?
No, I'm led by Mr. Sanal. He's on legs, my lord. I pay your lordship's leave to my lord file this affidavit. Next page. My lord, your lordship kindly, my lord, come to paragraph 6.
Paragraph 6.
My lord, the board in respect of the selection and recruitment of primary teachers in the primary school throughout the state of West Bengal is recommending authority by preparing panels for the appointment of primary teachers. Therefore, the board is bound and obliged to conduct the complete any recruitment process of the primary teachers in accordance with the prevailing recruitment rules and notification and guideline issued by the NCT. Well, next paragraph. It is clear that specific stand of the board that in respect of filling up the remaining vacancies in connection with the selection process initiated in 2020-22, the board have acted and will act strictly in accordance with the provision of recruitment rules and guidelines recruitment process of 2022 and notification issued by the NCT without, my lord, kindly, my lord, without compromising the merit position of any of relevant candidates. Any candidate, my lord. The board cannot compromise the merit of the, my lord, any candidate. The last occasion, my lord, we also submitted that. My lord, this is absolute a premature repetition.
No, very good. Then read.
My lord, then, my lord, the candidates of the present applicant has already been considered by board in 2020-22 recruitment process. What is, my lord, my learned friend is, my lord, agreeing, my lord, this. And but the marks obtained by the applicants are below cut-off marks of the respective category. My lord, that is why he was not considered, my lord, when the 9,000 and odd panel was prepared, pursuant to the order of the Supreme Court.
So you considered them also in respect of 95,000 vacancies.
Absolutely.
But they did not come within the cutoff.
Cut-off.
Very good.
My
Then applicants are not similarly circumstanced. Now we only then what is your instruction that
My lord,
merit position will not be compromised?
Yes, my lord, paragraph 7, my lord, last line. The NCT without compromising the merit position of, my lord, kindly mark any of relevant candidate, any, my lord, those who have appeared in the selection process of 2022, my lord, recruitment process, none of the candidate, my lord, will compromise the merit of none of the candidate. Your lordship recorded your lordship last occasion, that is why my lord asked my lord that I will dispose of the even writ petition also. The last occasion is fallen from your lordship, my lord. My lord, that is why, my lord, we have not prepared the panel yet. My lord, we will prepare the panel. My lord, if it is found, my lord, 2020 and 22
What
batch,
is the remaining vacancy according to you?
2000 something, my lord. It was 11,000 and odd, 9,000 and odd were appointed. my lord, 2000 and
No,
odd were.
simply, Mr. Vishwas, tell us now. You have written it very nicely, but you tell us that these persons have admittedly participated.
Absolutely.
So far, 9,000 approximate vacancies filled up. They did not fulfill the cutoff or
No.
come within the zone of
Zone of
consideration.
consideration, not cut off marks.
Zone of
Zone of
now, so far as the remaining vacancies are concerned, you will consider all relevant candidates.
Yes.
all relevant.
So that
Therefore, all
relevant
relevant
candidate
candidate
means
those who those
who
who
have
applied
applied.
for 2022 recruitment process.
We will record that and
Your
disclose.
lordship dispose it of. My lord, even my lord, the writ petition also your lordship dispose. Your last occasion, your lordship. My lord, because then my lord, I have to argue before your lordship. My lord, both way, my lord, he cannot, my lord, cut the cake, my lord, in the both ways.
Show the
My lord-
your writ petition prayer show.
My lord, the appeal, my lord, my lord, the mandamus appeal cannot be maintainable against the my lord order. Your lordship
Which
clearly see
order
the
he
impugned
has-
order. My lord, that order, my lord, the direction for filing affidavit.
That is
Page
page
34.
17th of June.
My lord,
This is order under challenge.
challenge.
That is challenge.
My lord, they
Yes.
could have filed their affidavit in opposition stating all these things. My lord,
Acha, acha,
instead,
well,
But if I do
we are
not file, my
solving
lord,
the
let
problem.
him, my lord, proceed with and my lord, get
We
the
are solving
order
the
expertly.
problem. Nah.
my lord, page 34 is my prayer.
Acha. Now, where is the order of Justice Bhattacharjee in the writ petition?
Starting from page 253.
253.
Yes. My lord, this order needs to be read with my lord, order dated 6th of May 2025.
We will record this, Mr. Alamgir. What remains then? Nothing, no grievance subsists, na? They are saying we will, in respect of the remain, we will quote that paragraph
Yes.
and we will record his submission.
In respect of remaining vacancy, my lord, they will consider every candidate who
Who
cross
have
the cutoff score.
participated?
Yes.
Who have
My
participated?
lord, then everybody will come before your lordship and your lordship
this
has to
will settle
record
the
my
issue for
everything,
one-
my lord.
For all also.
My lord,
That will settle for
Yes.
everybody. If they come, you show this order. Acha, where is the order of the single judge?
254. 254 and order dated 6th May 256.
So, oh, acha. 254 is the order under challenge.
yes,
And
Read with order dated 6th of May 254.
this is not the impugned order. The impugned
256
order is
also you
254.
have challenged.
Because my lord, in 256 their stance was different. My lord, in 254 their stance was different.
Appeal is against which order?
My lord, 17th of June 256.
Very good. Now, by the next
254.
order, of,
The appeal is against, my lord, I believe 254.
right now 256, they have the court has further read the facts and asked Mr. Sannal to take instruction.
My lord, this instruction can be submitted there also.
Then, my
Well,
lord,
insisted before your lordship, my
dismiss
lord.
the appeal, my lord, will go back to
Please
the
tell us, earlier there was a direction for affidavit.
Yes.
Now in the next order, that direction is not there.
No.
Next order is the earlier order.
Earlier occasion, there was a direction for instruction.
Oh, acha, acha.
The
Next
next
order
order
is the
filed
earlier.
affidavit.
Right.
Upon my lord hearing the submission of Mr. Sandal,
Right.
lordship was pleased.
Acha, where is the now appeal court order?
Supreme Court.
Against that, ওটার থেকে এখানে
This is the appeal, man.
আচ্ছা, and in the meantime the Supreme Court issue came.
Well, this is altogether a separate proceedings, my lord. This issue
No.
for the Supreme Court is altogether a separate, my lord.
Now,
That is their shielding, my lord. They are saying that this is a separate proceeding. This is the same
what
recruitment
is your
process.
problem, sir? Now this in this this special leave petition was filed for what prayer in connection with another proceeding.
My lord, may I pray, my lord, 2 minute times before your lordship,
This
my lord,
special
just clarify.
petition was filed by 2020-2022 DLED.
দাঁড়াও না। This page
243 to 44, my lord, operative part.
acha, that was filed by the 2022 persons.
Yes, 2020-2022 DLED pursuing candidates.
Acha. In which you filed an intervention. Then Supreme Court said that thereafter, as it was not being considered, you came up. Acha, the 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 present appeal has been preferred. Challenging an order dated 17. Mr. Aramgir, correct us if we are wrong. Challenging an order dated 17 June 2025, passed by the learned single judge in the writ petition being WPA 8959 of 2025. Stop. By the said order, the learned single judge directed the parties to exchange their evidence. Mr. Alamgir, learned advocate appearing for the writ petitioners, appearing for the appellant stroke writ petitioner submits that the West Bengal, it is the board or council?
Board of Primary Education.
Acha, that the West Bengal Board of Primary Education, bracketed hereinafter referred to as the said board, initiated a selection process for appointment to the post of primary teachers by a recruitment notification dated
29 September
29th of
2020.
September 2022. 29 September 2022. Stop. The candidates who completed the D stop EL or EI?
EL. D full stop, EL full stop,
ED.
ED course. ED course. For the session 2020-2024.
Two, my lord.
2022. Also preferred an earlier writ petition.
Yes.
Also preferred an earlier writ petition for consideration of their claim. Huh, Mr. Alamgir?
Yes, yes.
For consideration of them. The said proceedings were ultimately decided. This the dispute went up to the honorable. The dispute as alleged by the candidates who completed the disputes of
The dispute.
the dispute as alleged went up to the honorable Supreme Court. Went up to the honorable Supreme Court. Stop. The appellants herein also preferred an application for addition of party in the said proceedings before the honorable Supreme Court.
Intervention application.
Preferred an application for intervention, an intervention application in the said Supreme Court. Upon hearing all the parties, the honorable Supreme Court passed an order.
243, 244.
তুমি তো এক্সপার্ট, আমাদের তো বের করতে হবে। Passed an order on 4th of April 2025, annexed at page, annexed at page, no, 4th of, passed an order. কবে অর্ডারটা ছিল?
4th of April 2025, starting from page 213.
Passed an order
4th April 2025, my lord. 244 page 244
Passed
is
an
the order
order.
that is written.
on 4th April 2025, annexed at page 213 of the present stay application. Directing inter alia by the said order all the applications for implement preferred by the appellants herein and others
Or others. Several applications were filed.
were dismissed as withdrawn. And the applicants therein were permitted to avail such remedies as are available to them in law. It was further observed that if remedies are invoked, their prayers will be considered and disposed of by the respective courts or tribunals on their own merits. Mr. Alamgir further submits that panel of 9,500 was subsequently after Supreme Court order.
Yes.
Pursuant to order.
Pursuant to, Supreme Court said that you publish the panel.
Where publish the panel, where it is given.
They filed an affidavit before the Supreme Court that saying that our panel is ready. The Supreme Court said you publish it.
Where is that?
But in the orders, yes. I have annexed that order also.
Supreme Court initially enjoined the malad to publish the panel. Thereafter, malad, the another hearing, malad.
Last line ta ki likhle?
Mr. Alamgir further submits that panel of 9,500 was subsequently
The copy of order. The order আছে মনে হয়।
Mr. Alamgir further submits that pursuant to an earlier order passed by the Honorable Supreme Court in the said proceedings, submits that the Honorable Supreme Court by an order passed in the said proceedings
29th of January 2024.
2024.
on 29 January 2024,
Page my lord 374.
bracketed 374 legal 374 directed the board to publish the panel. তাই তো? আচ্ছা। Complying with such direction,
Yes.
the board published the panel pertaining to 9,533 posts.
My lord, including 5%. My lord, this should be recorded, my lord.
It is recorded in the order also.
Including
The 5% additional panel.
including the 5% additional panel. Mr. Alamgir further submits that the names of the writ appellants hearing did not feature in the said panel, and that no panel till date had been published pertaining to the remaining vacancies being how many?
2,500 plus, my lord.
Being
1,108 probably.
approximately
Remaining vacancy
remaining
from the
vacancy.
malad.
approximately 2,232.
Remaining vacancy, malad, your lordship, because the vacancy was 11,758.
Correct minus করো না কত হয়
11,758.
হ্যাঁ
9,533. 2,225.
লিখলে
But in even, malad, your lordship kindly do not figure out.
approximately
Approximately.
বলুন।
Mr. Alamgir further submits that the names of the appellants hearing did not feature in the said panel, and that no panel
and that
no panel till date had been published
Mr. Sannal has gone down as learned advocate, and that is what I was pointing out.
Then he is not a learned.
Senior advocate.
এই করে দিও নয়তো আমাদের নিয়ে মুশকিল হয়ে যাবে।
Instructions to be taken in this matter if a lordship sees the order of 11th of September, 11th of November.
Page.
11th of November, your lordship.
Oh.
But apropos to instructions sent by the deputy secretary.
Yeah, just one.
Me?
Yes, yes.
Yes. No, I have taken the instructions with regard to.
আচ্ছা ও বলে নিক না।
Yes, Mulad, it was pertaining to paragraph number 2 and paragraph number 5 of the instructions by the deputy secretary. Your lordship wanted firstly me as officer of the court to look into the file and place it if required, Mulad. Now, Mulad, two things are there. Paragraph 2 talks about the proceeding, disciplinary proceeding, which I have ascertained that proceeding is there. A show cause was given to the petitioner in September, and he has replied to the show cause also, and charge sheet in the meantime has also been served upon him. So proceeding is there, apropos the instruction which is there in
Charge sheet submitted.
12th of November, yesterday. Show cause was in September. Show cause reply was on 4th of September. Petitioner has completely suppressed that part in the writ petition, neither annexed nor pleaded. That a show cause was given to him. Show cause is 1st September. 1st September is show cause, 4th September is the reply. Because I clearly remember Mr. Jana submitting that there is no proceeding at all. At least this much he could have apprised the court that yes, a show cause was given to me.
So, charge sheet is dated
12th of November. Now question is, why on 11th November, the deputy secretary had written that proceeding is there when the charge sheet was on 12th of November. That question may come up. The charge sheet is 12th November. Why did he write 11th November? Why wrong instruction was given?
No, he did not write in the order impugned also.
Well, that is why the file. Because all reasons need not be in the order itself.
Not in a line.
It is,
line is not
well, charge sheet has not, the proceeding has nothing to do with the transfer. Transfer is tenancy transfer. If he does not plead a case that it's punitive transfer, he has no case at all.
Your deputy secretary in page 46A.
Yes.
If he would have said that the proceedings have been
Well,
initiated,
that transfer is not for proceeding. Well, kindly, well,
but it may be 10C is you're invoking the power under 10C.
Yes.
Which relates to transfer.
Which relates to transfer, but he is making out a case that is punitive transfer.
16 September. 16 September order, it was
Page 46A.
Tenancy is written, my lord.
charge sheet is has been given on 12th of
November.
And show cause was 1st of September.
1st of September. Reply 4th of September. Transfer order says that we are invoking 10C. Your lordship wanted to see whether it is coming out of the blue or whether there is something in the file. My lord, I have got the e-notings in the file. Your lordship knows, my lord, now it is e-noted. So, my lord, the discussions I find are going on since August. With regard to the, your lordship wanted to be satisfied that there is a discussion with regard to the PTR ratio, the pupil-teacher ratio, whether it is at all there, whether the state has seen it, or it is just as a eyewash that in the garb of 10C, I am giving a punitive transfer or not. But I have brought the note sheet, kindly seize it. But from 25th August, this discussion, even prior to that, I have brought the relevant portion, my lord. But kindly, but I am not giving a copy to the petitioner, but it's my administrative note sheet, my lord, only to satisfy your lordship, my lord. I have brought it, my lord. But kindly seize. Note number 43 is important in the first page. Note number 43. Why the deputy secretary wrote that the proceeding is there. The board vide memo number 29 July 2025 has informed that the disciplinary proceeding against Alok Chaki shall continue as process. So, my lord, in July we were informed, the state was informed that a proceeding is there. That is why the instruction says that the proceeding is there.
The board informed us so. But your lordship has found note number 43, my lord?
Yes.
Yes, I have also brought the letter, my lord, if required, my
That
lord.
is annexed to the writ petition.
29th?
Page 46.
Yes, yes, the same letter. Yes, page, same letter.
Yes, then.
Now, my lord, kindly take note number 44 is query on the PTR. Kindly turns over to the next page, my lord. Note number 48. Note number 48. Second page, bottom.
Yeah, just a moment.
July July annex করা আছে but 29 July but 29 July perhaps
Page 46.
no malad it is a different letter. Two 230, yes. I'm sorry, I beg you, I stand corrected, malad. Your lordship has seen my note number 48. Your lordship will see that the Shukchar, Adorsho and Garden Reach, all the PTRs have been discussed here as far as back in 8th of September 2025.
Where is Adorsho Madhyamik?
Adorsho is note 48 second entry. Note 48 second entry.
Adorsho Hindi high.
Well, there's a typing mistake with regard to the number of teachers, but anyway, it doesn't change our case.
So in Shukchar,
Adorsho and Garden Reach.
Shukchar for 230 students. This is PTR is pupil teacher ratio.
Pupil teacher ratio.
So the ratio comes to 1 teacher for 230.
Yes.
And here Adorsho it comes.
Adorsho is wrong recording. It's wrong recording. There are 21 teachers.
This is
actually it is written as 6. It is 21 teachers are printing. Yes.
Then,
Your lordship will find that at page 45 it is written, but it is a bit hazy. In page 45 it is mentioned that it has 21 teachers. Page 45.
Of the
page 45 is a stay application. This typing mistake which is mentioned as 6 will be 21, and your lordship will get the figure at page 45.
21.
Yes.
And Garden Reach is his present place of posting.
So the pupil teacher ratio in Adorsho is
80 around 21 যদি হয় 80
page 45
it will be about 80. 1:80.
Pupil teacher ratio excluding headmaster. Excluding headmaster. Pupil teacher ratio.
Well, that is question is not the figure. Question is whether it is punitive or not. Whether state had reasons in its file or not. Whether there was some deliberation or not. Because without the deliberation, the action will become arbitrary. Whether there is some application of mind into the process or not. That is the purpose. The purpose is not to show whether the ratio is right, wrong, etc. Prior to the transfer, whether there is some deliberation on the subject or not, or whether someone suddenly entered into the office and give a transfer order to this person as a punitive transfer. Whether there are some reasons behind the action, that is the purpose. Then, Malad, in note number 50, his present posting, etc., has all been discussed. Therefore, my lord, your lordship can see that the file has gone back and forth with all the data which was there. All the PTR was discussed, which brings me to the instruction note number 5, which was the second query which fell from your lordship. One was whether DP was there or not, and number 2, whether PTR was at all discussed or not.
What is this Halkia Bikram Vidyalaya?
Shalkia was also discussed previously on 2nd of September, because there are also 22 teachers.
2nd of September, where?
Second page, top note, note number 45, second page of the file noting, top. But it has a lot number, many teachers than Shukchar. আগে থেকে দর্শক জানে।
দাও তো একটু।
And my lord, we have also given a letter to the board requesting them that internal communications which are not addressed to the petitioner, it should not end up in the hands of the petitioner like this, because I find that these documents were never served upon the petitioner.
Which documents?
Page 44, page 45, 46. Apart from 46, 46 was given, but the 18 July, page 44. 18 July is a communication by DI to the secretary of the board, which was never served upon the petitioner. Though I understand by beg, borrow, steal, by any mode, he can bring a document before the writ court. I don't say that.
Why has he stolen? Don't omit the word steal. Omit the word steal.
No, no.
You don't act as the deputy secretary. You are a learned counsel.
No, no, Malad.
Don't add words to the mouth of your deputy secretary.
No, no, I am not adding word.
No, you use the term beg, borrow, and steal.
Malad, that
Why
is
you are
the.
assuming stealing?
Malad, that is a
What
phrase.
I should tell
But that is the entire phrase. Malad, it's a way of speaking.
It is most inappropriately applied in the facts of this case.
But Malad, it's a
extempore does not mean that I quote any idiom and say whatever.
No, but Malad, it's a phrase which is said together.
Expected from you.
Malad, it is
expected. Whatever may be the phrase, you before opening your argument, you must realize that which idiom you will be using.
No, Malad, it says or. Malad, I am not blaming anyone. I am also agree.
Please
that
don't castigate a person.
I have not castigated Malad.
Your choice of words was bad.
I also say that he may bring a document before the writ court, but this document was not meant for his consumption. It was an internal communication. With all the file notings, it has ended up with the writ petitioner.
Anything else you want to point out?
No, my lord. Just to summarize, number one, show cause and the reply has been suppressed by the writ petitioner. Number two, we were informed that a disciplinary proceeding is continuing. That is why it has been mentioned by the deputy secretary. And number three, the PTR was discussed by us in the file, may not be in the transfer order itself, but the transfer order explicitly says that tenancy has been invoked. And your lordship will kindly look at it from different perspectives, the DP separately and tenancy, invocation of tenancy separately.
Show cause was issued. You said 1st September 20.
Reply on 4th.
Reply on 4th.
Charge sheet on 12th November.
Reply all before even the writ petition was filed. So he was well aware of it. So the petitioner also should have disclosed it.
One, you said show cause. What was your next argument?
Show cause. Then Malad,
It was suppressed.
suppressed. Second thing was we were informed that the disciplinary proceeding may continue. That is why the Deputy Secretary has mentioned in note number 2 of the instruction that the disciplinary proceeding is running. But which was handed over on 11th of November.
No, that was on 25th August. It was first placed before your deputy on 25th August, no?
No. Malad, yes.
25th August.
No. Communication is dated 29th of July 2025 by the board.
That is the page 45.
This is page 46. And the third thing is that the PTR has been discussed in the file, though not mentioned in the transfer order.
20. Now, what is the distance of the school from the present school?
Mullah, that I have not ascertained, Mullah. That was because that is not his case, that it is far away. His case is that it's a punitive transfer. As per the pleadings. At the bar, what has been submitted, Mullah, that's a different thing. His submission, your lordship will find at page 29, paragraph 13. Page 29, paragraph 30. That is his attack to the transfer order.
Paragraph 13.
13, 15, that is his attack.
Yes, Mr. Jana. You want to point?
I don't have any file. Only the charge sheet issue, that was mine.
Yes, Mr. Jana.
The matter was, my lord, the hard on and from 31st October 2025 onwards, my lord, the court's query was whether I will be transferred to Adarsha or Sukcha. This is the one aspect. Another aspect, whether the transfer order can be issued under section 10C or not. Since, my lord, the court insists, my lord, for considering the transfer to Adarsha, my lord, why transfer order will not be issued to Adarsha, my lord, in terms of the first report of the second report, it is admittedly, my lord, the transfer order was issued 10C, it appears from the September also, my lord, the report that transfer order is issued on the basis of the board's letter, page 46, for initiating disciplinary proceedings on the alleged complaint. Page
Board communication.
Board communication. And admittedly, on the basis of the communications, they are now, my lord, the proceeding terms. This is not the 10C transfer order. Apparently, my lord, they have admitted. First report also they have admitted, because of the chaotic situations, transfer, my lord, the petitioner should be transferred to somewhere. This is the, my lord, the first report also said.
Academic interest.
Academic interest, but not on administrative reasons. My lord, on the basis of alleged complaint, on the basis of allegations, my lord, that is the, my lord, the main board's letter, page 46, also they have admitted. My lord, I just, my lord, the note number 43. Now the questions, my lord, why not others? My lord, they says, my lord, according to the people teacher ratio, you also kindly see the second report they have filed. Second report, yes, paragraph 5. The petitioner was recommended for
second report means
my lord, the 10th November.
3rd November.
No, 10th November. My lord,
10th November. Oh, achha.
Yes, Mr. Mandwada, my lord, handed over this. Yes, day before yesterday.
the notwithstanding clause.
That's
And-
true.
And
That
kindly come to 10C, you have annexed.
yes, yes. My lord,
10C is at page 51.
page 51.
Please place it.
Notwithstanding anything contained in any other law for the time being in force or in any contract or to the contrary, the state government in the interest of education or in the
interest of education.
interest of education. What is the interest of education?
Academic interest should
No. Interest of education is the second report. They said, you will also kindly see, whereas in these circumstances it is quite obvious,
Just,
a
wait.
chaotic situation.
Chart, কোথায় গেল?
সেকেন্ড রিপোর্ট
Second reportটা তোমার কাছে?
সেকেন্ড এইটি যেটা পড়ছে
এটা তো first.
ডিআই
Second report is 3rd November.
3rd November, first report.
First
Hey, this is the report, second report, 3rd November.
This was the first one.
First.
3rd November.
3rd November, first one.
Yes. In the
Second page,
you are showing the second.
3rd November.
3rd November, yes.
Second page, second paragraph. In these circumstances, it is quite obvious that a chaotic situation is existing in the school. Second paragraph.
Second paragraph.
Whereas, this is the second page.
Whereas
Whereas,
chaotic situation.
chaotic situation is existing in the school, completely vitiate the academic interest of its children. So, my lord, this transfer order, they have issued the transfer order under section 10C on merely not the administrative reasons or my lord, the interest of education. On the allegation against me without any proceeding initiated. Proceeding initiated against my lord, yesterday has not yet my lord, served upon the appellant till date. My lord, just now, my lord, since the matter was heard, my lord, the day before yesterday, yesterday they issued my lord charge sheet. That I am not on that. I am not on my lord, Adorsho. Why my lord, my transfer order will not be considered to Adorsho. That is why my lord, the very first, my lord, the very beginning, my lord, I submitted that. Adorsho, my lord, since my lord, I was an assistant teacher in Adorsho. I, my lord, no complaint was never, my lord, 15 years, my lord, I was serving as assistant teacher in that school. My lord, the first, my lord, report, that is the, my lord, absurd, my lord, report, my lord, second report, 10th November 2025.
So that he has become subsequently more intelligent. That he has become subsequently a deputy secretary, he has become more intelligent. That how I can substantiate my order. That is all right.
That is. My lord,
That is all, paragraph 11 is all right.
Why, my lord, what is their problem to transfer me to Adorsho?
Mr. Jana, please see this aspect. You are also not being able to function properly. There had been non-cooperation. That huge amount which was left in
that DI has collected and deposited to the bank.
Right.
My lord, audit, my lord, is complete, my lord, up to the year.
Mr. Jana, kindly ascertain. What cannot be disputed is these allegations, certain allegations are there that you are not taking classes, subject to the disciplinary procedure. We appreciated your argument that it is penal in nature because in respect of one allegation, I am being first sent to one school, then I am being sent to other schools. And that according to you is penal. But Mr. Jana, kindly consider academic interest, this 10C application, today it has been placed before us, but this 10C application speaks of certain guidelines. And Mr. Jana, this academic interest, we cannot throw out just now.
They can suspend me. They can suspend me. Even that is why, my lord, my lord, they can suspend me for timings.
যে আমার against the proceeding আরম্ভ হয়েছে, আমি যদি আদর্শতে যাই তাহলে আমি
And also, my lord, the
রিফাইনমেন্ট তো
to Adorsho.
PTR, Mr.
PTR.
PTI, my lord, the excluding headmaster. My lord, the headmaster is not the, my lord, the PTR is not applicable to the post of headmaster. Headmaster is the post of alone. Even there is no teacher, headmaster, my lord, the post of headmasters, my lord, is required to run the administration. So this is not the, this is, my lord, the cleverly, my lord, they said, my lord, the comparative, the PTR. This is not, your lordship,
Are
kindly
you
see.
disputing that that is not the figure? Because DI's order also reflects those two figures, 12 teachers. So the PTR comes down, headmaster does not come, all right. But the headmaster in a school having 21 teachers and the headmaster in a school having 6 teachers, that may create a dispute.
More, my lord, that 21 teachers, that school will, more, my lord, will be suffered. Because there are, my lord, about 1250 students.
হ্যাঁ সেটা তো মাইনেটা দিতে whether it is to Adorsho or
That I,
Picture.
on,
Uh,
no, that submission was, my
transfer
lord,
order is penal.
that submission was made from the bar, my lord, from beginning, that the apart from the 10C, my lord, the transfer order, I can accept only others. So that because the there are, my lord, the 21 teachers without running, my lord, master. DI has specifically.
The PTR in your school, Adorsho, is much better compared to that school.
No,
That is fact and figure.
1250 students without headmaster. My lord, this is the, my lord, that school also, my lord, the more, my lord, the facing difficulty.
You are interested to go
PTR,
to your
people teacher ratio does not apply to the post of headmaster. There are, my lord, that is the.
Sana, you had been there for 12 years. We could have we didn't know this fact. These 12 years you were previously there. The client, your petitioner maybe that was not disclosed, maybe. Mr. Jana, why you cannot work peacefully also? Today you cannot work peacefully because their report shows there is a chaotic. You yourself have said that I am not being allowed to join since the matter is in scene of the
Because of the transfer order, board through electronic mail.
We will say that pertaining to that period that has to be regularized. You cannot be penalized for absence during that period because the matter was going on. That protection we will give you, Mr. Jana.
That period will be regularized.
My lord, that is your lordships, my lord, from beginning, my lord, I submitted before lordships.
From beginning, we
either your lordships, my lord,
we thought, as you have argued, we have recorded in our order also. It is not that it is a
Yes.
prima facie understanding which we were having. That is why we recorded, so that the government, yes, this after hearing of the matter on that, they had no other option but to issue the charge sheet. There is they are also not clean, but the thing is that what after so much of fighting you will go back to a school where you cannot peacefully work also.
Why not? Only, my lord, that money was collected from development fund as per decision of the managing committee. Ultimately, that fund has been deposited to the bank. I face the, my lord, the proceedings initiated by charge sheet has been. I will face. But this punishment, my lord, this transfer cannot be sustained. Entire, my lord,
But as the proceeding has already been initiated, and as the proceeding.
And also, my lord, the transfer rules, there is a specific clause. Your lordship kindly see, I read it. General transfer shall be allowed on an incumbent against whom no judicial or disciplinary proceeding is pending and contemplated and who is not under the suspense. My lord, I cannot apply also for transfer if the judicial proceeding or disciplinary proceeding is pending. This is also, my lord, the transfer rules not applicable. But all these things, my lord, the proceedings two part, either, my lord, to initiate proceedings or
That one thing, your lordship,
The-
because proceeding has.
The appeal in
Always good for him.
কোথায় নেই? দেবপ্রিয়কে ডাক, দেবপ্রিয়কে ডাক। কেন? দেবপ্রিয় নাম দে। এই ওটাকে নাম দেওয়া হয়েছে লাইটটা? আগেরটা নাম দিয়েছে লাইটটা? দিয়েছে?
Wanted to know whether my client will go for appeal, my lord.
Yes.
Now, my lord, I checked up the provision, possibly appeal does not lie, my lord.
No, appeal is no, it is not said appeal. Only kindly.
May I, my lord, hand over the contract?
We have.
Kindly don't, may I request, my lord, your lordships, kindly don't rely on that, my lord.
Rely on?
On that book.
Some discrepancies.
Right.
I was, Mr. Shahar, I purchased 3 copies.
He's a rich man.
Definitely. I checked and found the discrepancy, and that is why I did not purchase.
More clever.
Now, kindly look into clause 24A. Yes. Page 25. Now, in the book, your lordships don't find this.
This is an amended portion.
Yeah.
Why do you say appeal does not lie, Mr.?
Kindly come to 25.
Yes.
Any dealer or FPS licensee aggrieved by an order of the subdivisional controller denying the issue or renewal of the license to the fair price shop owner or cancellation of the license. Here, my lord, there is imposition of penalty. Fine. That is, my lord, 24A. Yes. My lord, there is no, my lord, denial of issuance or renewal of license or cancellation.
There was a suspension.
Suspension is subsequent, my lord. I am challenging suspension on the basis of the order of penalty or fine.
Or non-payment.
For non-payment.
In the given case, you preferred an appeal before the district controller.
That is 25 itself.
Under which provision?
Clause 25.
Agreed by an order of SD subdivisional controller.
Yes.
You
May I
preferred
read
appeal?
it?
You preferred appeal?
Prefer an appeal to the district controller if and is concerned within 30 days from the date of receipt of the order of subdivisional controller concerned, and on receipt of such appeal, district controller concerned shall dispose of the appeal within 60 days from the date of receipt of the appeal petition after giving opportunity of hearing to the appellant. If the FP shop owner is aggrieved or dissatisfied with the order of the district controller, food and supplies concerned, he may appeal against the order of the district controller, food and supplies concerned to the director DDPS.
Yeah, Mr. Bandyopadhyay, what?
Yeah, one thing, one clarification. Here, the order by which a certain amount of money was imposed as a fine.
Yes.
This order was passed by the subdivisional controller.
Yes.
You challenge this order before the district controller.
Yes.
So under which provision you challenge?
25.
That appeal.
But that was, I was, in the,
Could not have,
I,
could not have. But that's, my lord, a wrong recourse to law, my lord, does not make it, my lord.
After filing appeal decision, Mr. Mitro, can this be
I
argued?
have challenged both, my lord. I have challenged both for the simple reason, my lord. I have on the last occasion shown your lordships that the order is that from 2015.
Please show us that order against which you went up to the district controller.
Yes, my lord. Kindly come to, my lord, page 66. The penultimate paragraph, because before that, my lord, kindly come to the first paragraph. Whereas a complaint from so and so and others was received by the Food and Supplies Department against FPS owner, that is the petitioner, writ petitioner. Now, till date, no copy of the complaint was given to them.
That is another aspect. First, let us clarify this, whether any appeal is there or not from the order imposing a fine.
Where is the order of suspension, Mr. Mitro?
The order of suspension, my lord, kindly come to page 80, 84.
After this order? After 30th of July?
Yes. After 17th September. 17th September is the order of the district controller. The very next day, the subdivisional controller says that he was suspended.
Where is that order?
Page 84, my lord. First order is page 81 of the district controller.
No.
Kindly come to page 83.
No, the first
66.
66 is the penalty order.
That is the order.
Penalty.
Ask for cause or anything like that.
Where was the suspension issued when?
That's 84.
Oh, you have never been
After the order
suspended
of
earlier.
penalty.
Suspension. You have never been suspended earlier.
No. And after, my lord, the district controller gives me 10 days time to pay the penalty. The very next day, the, my lord, subdivisional controller issues the letter. When he had no jurisdiction.
Is the imposition of penalty under section 24(2).
Kindly
It has
give.
been written in the order.
Yes, yes,
This is the order of the subdivisional controller.
yes.
Now, against this order, you went up in appeal.
Yes, my lord, kindly come to page 81.
Under which provision? Under which provision?
My
The
glad
appeal you preferred under which provision?
25. It's a wrong, there was no provision. It's a wrong step taken. And my lord, that is why, my lord, in the writ petition, I did not challenge only the second order. Both the orders were challenged.
The second part you succeeded. Court said that suspensions could not have been issued on that date.
That is part, but the penalty continued. Now, my lord, recapitulate, my lord. First, in February 24,
No.
a show-cause notice. I respond to that. My lord, a hearing is given. No order is passed. I lodge a complaint with, my lord, the concerned, my lord, minister in writing. Those are all part of record. Then, my lord, after that, the next show-cause notice comes, my lord, in June. June 26th, the second show-cause notice. Neither in the first show-cause notice, nor in the second show-cause notice, there was any whisper of, my lord, any irregularity since 2015. Lordships can take it from me. I have carefully checked it up. I can show your lordships both the show-cause notices. No charge. Then, my lord, hearing given, the order comes of the subdivisional controller saying that I have indulged in malpractice since 2015. Even in the minutes, it's not recorded. Hearing minutes. Now, I challenge that order before the district controller. With respect, my lord, I would say it's a mechanical order.
Form 4 নিজেই ইস্যু করেছে তো পেজ 66 টা দেখেছো 1 2 3 4 আগে কিছুই করেনি ক্রেডিট কার্ড হয়ে যাওয়ার পরেও ওইগুলোতে টপিক আছে
এখানে ওয়ার্কআউট করা আছে
Where is the penalty calculation sheet, Mr. Mitro?
It was not given to me, my lord. That is
not given to you.
Opposition.
In the opposition, yes. In the opposition itself.
Page.
I will. Kindly give me a minute's time, my lord. এটা দেখেছিলাম, sorry. Kindly come to, my lord, page 191.
Here.
But my petition, my opposition is on record. And
We
it
are
has,
asking you, you need not file.
I need not file any more documents.
Then because we were, then it has to be hard on merits, no? It has to be hard on merits.
And one interim order is to be given, otherwise up to 15 November, there is an interim order.
But they have not been depositing the amount from the first day, that is 30th July 2024. Already one and a half years.
It was stayed.
1.5 years.
Kindly come to page 86. The interim order is continuing.
31st July?
But the amount was imposed upon them on 30th July 24.
No, it was imposed upon. Oh, acha.
Oh,
কত বললে, হ্যাঁ। Yes, it was on 31st July.
Then, my lord, the
30th July.
30th July, then district controller's order is 17th September, and my lord, the interim stay was granted on 25th September. Page 86.
Page 86.
Yes.
But time to deposit may be extended for some time, then suspension. Time to deposit may be extended. They
How can we say extending the
meaning
that goes to hold
meaning
against?
that till the pendency, my lord, let them let them deposit, keep it without prejudice, let them deposit some amount. For 1.5 years, they have not deposited.
Kindly come to page 80.
Even by virtue of the honorable single judge order, now your lordships are considering, let them at least before the register, let it
Mr. Bandyopadhyay, there had been interim orders to that effect.
Yes, not to deposit, but the but not on the suspension. The suspension continued.
No, suspension portion was revoked by the single judge, saying that you have come within that.
Yes,
period.
by giving a time to deposit the amount.
Right.
Right.
That time is expiring on 15th.
Right. They'll let the suspension continue.
Huh?
Let,
Suspension, even it revives, na, he won't be able to operate after.
may I say this? Initial interim order, amount deposition was stayed. Suspension was not stayed. Appeal preferred.
Suspension order was issued on. কোথায় দেখালো জানো?
88. Kindly text page 88.
That is only after the district controller's order.
Yes. District controller's order, thereafter suspension.
Suspension was
They
issued.
came up challenging both. They came in the read.
Suspension order, which page?
84.
84, madam. Yes. Before that, my lord, kindly once come to page
18th of September was the suspension.
Right.
Kindly come to page 81 once.
Yes.
Page 81 at the top on the right hand side, lordship should find the date is 17th September. And my lord, kindly come to page 83.
17th September. 84 is the suspension.
No, kindly come to page 83, my lord. I was given 10 days time to deposit the money. The bold. In view of the above.
Well, may I make one submission? Well, may I make one submission?
Yeah, yes.
Well, initially they challenged by way of interim order, they wanted interim protection, that is stay of the suspension, stay of the depositing of the amount. The honorable single judge only permitted a stay on the.
No, Mr. Bandyopadhyay, as you suggested that you said that you
kindly
extend the period of filing.
Yes, but not the suspension. Kindly allow me to clarify the position. The honorable single judge gave a stay on the deposit, but not any stay on the suspension. They moved a clarification. The honorable single judge said
it gets penalized, na, Mr.
Well,
Bandyopadhyay.
it has been tested already. They went up in appeal. Well, they went up in appeal.
Appeal against which?
The interim order, where the suspension was not stayed.
Oh,
the
where is that order?
Yes. That Malad, the Honorable Appeal Court said that there is no reason to interfere with the order of the Honorable Single Judge. Page 93. So the suspension continued from that day throughout. Then the Honorable Single Judge, while deciding the matter, said that suspension will be revoked upon deposit of the amount. Now they say that we don't want to deposit the amount. I am all right with that. Let them not deposit the amount, but the suspension, let it continue because it has continued.
Tell us, please go a bit slow.
One by one, if I may please. One by one, Malad.
So they went up in the first petition challenging what?
Challenging the interim order where there was no stay granted on the suspension.
That is 8th October 24.
Malad, yes. No, first order is 25th September 2024. Page 86.
Where is that portion not granted?
Yes, page 88.
Hmm.
Kindly text 88.
Hmm.
Direction for affidavit reply. In the meantime, there shall be an order of stay as regards the operation of the order of penalty imposed upon the petitioner for depositing 7 crores 85 lakhs. So far as the suspension order of September 18 is concerned, Mr. So-and-so informed that the court that the same has been made effective this time. Let not any further step as regard the same be taken by the respondent authority like declaration of vacancy or undertaking any process for grant of dealership. This order was granted. They moved a clarification application before, that is page 90.
Let no further steps as regards the same
Yes.
be
But
taken by like declaration of
vacancy, meaning the suspension was not stayed. Only I was restricted from declaring a fresh vacancy. Now they moved a can application, page 90. Kindly take page 90. The Honorable Single Judge clarified her lordship's order.
Page 90.
Page 90 it starts. Kindly take page 92, the concluding part of the order. That is in the application for clarification. Can 1. 92 I am placing, my lord. On careful perusal of the records as relied on by the respective parties, the court is unable to ignore the physical record of stock transfer with a certificate as above, which contains petitioner's signature. Therefore, prima facie, the stock transfer process has been done on 21st September 24, prior to the date of the order of this court. Secondly, the legality and propriety of the order of suspension or dealership under challenge in this writ petition, restraining the suspension order to be given effect to during the period of pendency of the writ petition, would amount to grant the ultimate relief to the petitioner without trial. That would not be a proper course to adopt at this juncture. This court is of the considered opinion that there is no scope to modify the order dated 25th September 24. Then they preferred an appeal for the mandamus appeal. That is page 93. These two orders were sustained in appeal. The Honorable Division Bench held that there is no reason to interfere with the discretion applied by the Honorable Single Judge. That is, your lordship will find at page 95. And directed expeditious filing of the affidavit and reply, etc. But then the matter was heard before the Honorable Single Judge. Suspension continued throughout this period.
Oh, achha.
Then, when disposing of the matter, the Honorable Single Judge held that upon deposit of the amount, the suspension will be withdrawn. They now do not want to deposit the amount. That is suspension continue. That is my submission. They, having tested those interim orders and failed, today they cannot, in a different manner, ask for that same interim order and say that because no situation has not changed. But if they want a revocation of the suspension, according to the Honorable Single Judge's order, let the amount 7 crores 85 lakhs be deposited somewhere. Not with me, let it be deposited with the registrar. If your lordship are minded to, prima facie, to revoke the suspension at this stage, because it has continued.
Page 88. That order has been affirmed by a coordinated bench.
Yes, my lord, that
there
is.
will be no declaration of vacancy. Suspension.
Yes, because it is not a termination anyway. Anyway, it is not a termination, it is a suspension. So there is no question in any event for me to declare any vacancy.
Then we are fixing a date, Mr. Mitra.
May I? Kindly
Yes.
give me 2 minutes time.
Yes, boss.
Interim order. Thereafter, my lord, a clarification and my lord, the appeal. That was at the interim stage. At the final hearing, my lord, the learned single judge was pleased to pass an order. My learned friend submits that the order is that upon deposit of money, there would be stay. Kindly come to paragraph 27 of the impugned order. Page 227 or the memorandum, whatever it is. my lord.
On deposit, just a revive. I was relying on 29 actually.
I shall come to it.
Yes.
Kindly come to paragraph 27. It further appears that the subdivisional controller food and supplies, after disposal of the appeal on 17 September 2024, has issued the order of suspension on the next day, that is on 18 September 2024. By passing such order, the subdivisional controller concerned has itself violated the direction of the appellate court. He was required to wait for 10 days from the date of receipt of the order by the petitioner. Therefore, the order of suspension dated 18 September 2024 by Subdivisional Controller Food and Supplies has been issued in a post-haste manner. Thus, the order of suspension appears to me to be not proper. However, the merit of the suspension order cannot be quashed entirely, but it requires to be stalled for some period, allowing the petitioner to carry out comply order dated such and such. Under the above observation, the order of suspension passed by the subdivisional controller dated 18 September be stalled till 15th November. Petitioner is permitted to deposit amount as mentioned by the appellate authority vide its order dated 17th September within 15th November. Failing which, the order of suspension dated 18 September 2024 issued by subdivisional controller shall be revived in its true force. Then, on deposit of the amount, the license of the petitioner shall revive.
এখন লাইসেন্সই নেই।
Under the above observation, the instant writ petition is disposed of. Now kindly come to page 229.
So, as it stands today, Mr.
Yes.
Admittedly, your suspension is continuing since that date, 18th of September.
It has been stalled. There is no appeal by them as on date.
No, it has been stalled. But this argument
Kindly,
was,
my lord,
it was advanced by you before at the interim stage itself. Same order of suspension.
at the final hearing, my lord, kindly, my lord, interim
Final
stage
hearing, we will hear you.
of the writ petition. At the final hearing of the writ petition, my lord, the court is entitled to, my lord, modify, my lord, the earlier interim order. There can be occasion where, my lord, at the final hearing, the court may say that no, though I have passed an interim order, nothing will be there.
But what is the change in circumstances?
The affidavits were considered.
Very good, but the fact
affidavit-
remains that your suspension was not interfered with. Fact remains that.
At the initial stage, but subsequently.
Interim went up in appeal, confirmed. Now the writ petitioner, after a coordinate bench has accepted such view of the interim stage by the judge.
At the interim stage, kindly, my lord, consider this. My lord, then, my lord, in
We
that
are fixing a date for
that
hearing.
event, my lord, kindly consider this. Now, my lord, in that event, my lord, if an interim order, kindly take a hypothetical situation. I move an application and interim order is refused. I prefer an appeal from that. The appellate court does not, my lord, interfere with the first court's order, the trial court's order. My lord, that does not mean, my lord, at the final hearing, my lord, the petition will not be allowed. Or, my lord, the appellate court will say, no, since, my lord, since you could not succeed in the earlier appeal.
Mr. Mitra, you are seeking the self-same interim order, which was refused in the earlier round of litigation. The interim order which you are seeking is
Earlier round, my lord, at the initial stage.
whatever may be.
After hearing, my lord, after the final hearing, my lord, the order was passed.
I am praying for continuation of the.
I am just praying for, my lord.
That is why, since since appeal is continuation of the appeal, res judicata will apply at different stages of the same proceeding between the same parties.
Then, my lord, kindly come to page 229.
And their appeal is not limited to a portion of the order.
Kindly come to page.
In the memo, they have not clarified that we are only challenging some part of the order. They are whole of challenging the order, not those which are favorable to them. নেই তো ওরা শুধু স্টল করেছে পেমেন্ট দেখেছি আমি দেখেছি it was stalled for some time enabling them to deposit the amount if they do not want to deposit the amount তাহলে তো পুরোটাই বেকার
of the order. Kindly come to page 229.
Yes.
Letter of 9th October. After the final order was passed, in compliance with the above judgment passed by the Honorable so and so, in the matter of so and so, suspension order issued video order dated 18th September is hereby stalled till 15th November.
Enabling them to deposit the amount. They do not want to deposit the amount.
Then why do I prefer an appeal? I don't prefer an appeal. If that is, my lord, the contention before your lordship with
So
greatest.
then, Mr. Mitra, you deposit the amount, you stay the suspension.
Yes.
7 crores, what is the amount?
7 crores, 85 lakhs.
8 crores of rupees. Without any basis. Without any basis.
If you succeed in appeal, you will get.
No, that's a different question, my lord. 8
Along
crores
with
of,
interest. Don't worry.
8 crores of rupees, my lord, is not a small amount possibly.
No, we are fixing up the date. We are extending your time for deposition till that suspension order which has been deferred. This 9th of the suspension we cannot
But
interfere.
they have not challenged the order.
Why will you?
They have not come up before the court saying that this suspension order could not have been passed. On the contrary, they have accepted this.
No, এটাই। Own submission.
Dealership.
I have shown
Of
you,
all the reliefs at the interlocutory stage.
I have shown you, lordship's my lord, the order. Now, my lord,
Your ultimate relief, don't ask me to deposit anyone and allow me to run the dealership without taking any
my lord,
coercive step.
it
Is your ultimate relief.
no.
Now,
It has continued for some days.
If you want interim order, we have to put you on terms, certain terms. And if you don't interim order, so we are fixing a date for final hearing. So it is up to
Kindly once come to my lord, the second paragraph of page 229.
We will hear you, Mr. Mitra. On that date, we will hear you, we will dispose of matter finally, because he says all the documents are on record.
Yes, all the documents are there.
So we will fix it in the first week of December. Till such time, you don't have to deposit. দুটোর সময় এসে দিয়ে দেবো।
But suspension order will.
So if you argue that suspension, then we have to reject the prayer. No?
Now, my lord, if I may put myself the question. Now, my lord, if I was told that, well, you have done something wrong from 1980, you are liable to deposit 100 crores of rupees. What would I have done, my lord? If I am told today, kindly consider, my lord, I am faced with a penalty for which, my lord, or in respect of which I did not get any opportunity to respond. 2015, your lordships have seen the calculation sheet. It does not speak of 2015. Till today.
From where?
Prior to 2020, was I given an opportunity to say that? The entire, if your lordship kindly come.
Strike it down, Mr. Mitro. Today we cannot hear, Mr. Mitro. If you are wanting, then it will be at your risk and call. If you don't want to-
The order is continuing, my lord.
No, Mr. Mitro, when it is not that we are deferring it indefinitely. You had been under suspension from September. Today we are in November. We are fixing in the first week of December. Problem ends. It is not that, Mr. Mitro, you will continue suffering.
No, my lord, I will tell you, lordship.
He will say that no further documents.
The difficulty is, my lord, it's not a question of not paying, my lord. There can be two questions. One is not, I will not pay, or I am unable to pay. These are the two differences. There are differences.
That is why we will safeguard you. You don't have to deposit now. We will safeguard.
I'm a dealer.
We understand, Mr. Mitra, but
You deposit, your deposition would be without prejudice to your rights and
That is
contention
definitely-
raised in the appeal.
That is definite. That
Your
is-
no, if
deposition.
you are not, you say that you are unable to deposit. In that case, we are not hearing the order finally, but we are giving the final relief at the interim stage without calling for any money.
Kindly once come back to 229, my lord. I am being.
Tried your best, Mr. Mitra.
229 has become redundant today. 229 was on the pretext of compliance. Now they do not want to deposit. 229 substratum is lost.
Initiate commencing for termination. Oh boy.
They don't have a license to run.
Kindly come to page 229 once, the second paragraph. I will stop there after.
My lord, the foundation of 229 is lost today.
I don't know, senior man, he's showing us some 229, Mr. Mitra.
The second paragraph.
Yes, yes, yes.
After the judgment, you were also requested to comply the direction of the Honorable High Court, that is to deposit the penalty amount of such and such, failing which suspension order issued vide such and such will be revived.
Yes.
Stall till 15th.
This till Saturday. It will revive automatically from Monday, Sunday.
Continuation of this order.
Revive করি। No deposition করতে চাইছে না।
That will automatically revive from Sunday.
চলছে
ওইটা বোঝা যাচ্ছে না।
সাসপেনশন অর্ডার ইস্যু হয়েছে
Suspension order dated 18/9
সেটাই
against
পেজ
all.
The suspension
Suspension is
80,
at page
84.
84. Could not have passed this order. He had no jurisdiction to pass this order. After page 83, he had lost jurisdiction in passing that order, and still he passes that order.
No, whether after 9, after this order, including this appeal, he was allowed to function.
No. That is what has been recorded by the Honorable Single Judge in the earlier stage, that the suspension has been given effect to. But I read out that page 93, that giving any relief now will be amounting to giving the final relief. That order they tested before the Honorable Division Bench, and the Honorable Division Bench said that the discretion has been rightly applied.
No, after the final order passed in the writ
Yes,
petition,
after the final order, the Honorable Single Judge directed us to give them a breather so that the amount can be deposited. So we issued page 229, asking them that deposit, and the suspension is stalled in the meantime because we were complying with the Honorable Single Judge order. Today, my learned senior comes and says that we don't want to deposit. The moment he says that, the substratum of 229 is lost. 229 is issued on the pretext, in compliance of the Honorable Single Judge's order, that he will deposit within certain time. Till that time, the suspension will be stalled. We have completely, that language is completely from the Honorable Single Judge what was directed. If they do not deposit, suspension will revive. We have also written so. The last page, paragraph 28 of the Honorable Single Judge's order says that if they do not deposit, suspension will revive. It will revive from Sunday.
Item number 4, 5 and 6.
Six. Item number 4, 5 and 6, I have been told by my other side, my lord, just now that they will be praying for an adjournment. I am the appellant. The other side is here, my lord.
Mr. Dasgupta, you don't have juniors.
My lord, that. Then.
Usually we do not at the time of rising.
My lord, my lord, my lord.
But this is being practiced, we see. At the time of rising, nobody should disturb the court.
My lord.
Ask your junior to be
My lord, before your lordship, my lord, the first half, Mr. Dibyendu Chatterjee mentioned one matter, but I was there, my lord. Your lordship fixed it on 19th. My lord, Mr. Sarnal is leading me. 19th, my lord, he has some difficulty, my lord. The one Pathad matter, the first item is.
Where is your other side?
My lord, I will inform, my lord. If your lordship, my lord, change any date or, my lord, anything, my lord, I'll immediately.
Bring him now. Bring him, we will change in front of him.
My lord, my lord.
Duck.
Your Lordship, I am for the appellant. I am led by Mr. Sudip Tejas. 456. 456 is for the respondent writ petitioner, Your Lordship. I am
It
for
was mentioned while we were rising. We didn't entertain at that time.
Is item 4, I'm for the commission. The other two matters, I'm not.
4, 5, 6, not this week.
5-6 my lord, I'm for the state.
5-6, my lord, I'm paying for 1 week time, my lord, led by Mr. Kamalesh Bhattacharya. His personal difficulties. my
That
lord.
day we asked you, no? 4, 5, 6 on 26th November. Next.
26 November.
Will you do it on unnecessarily on your mentioning we include, then some problem appears.
Your Lordship,
Are you sure in that fashion you mention?
Your Lordship,
Everyday matters are listed, everyday time taken. Earlier also this happened.
Namdev, Namdev.
Yes, পরেরটা রাখো। Yes.
Appearing on behalf of the appellant, my lord. Lord, the appellant, my lord, appeared in the TET 2014 examination.
Why it is defect?
It is just
2014 exam.
2014 exam, my lord, and participated in the interview in 2016, my lord. Thereafter, my lord, her candidature was not, my lord, told to her. She did not know anything. Then, my lord, in the year 2023, my lord, she filed one RTI application, my lord. And thereafter, my lord, in the RTI reply, my lord, they says that I have qualified in the 2016 process, my lord. Therefore, my lord, I took out a writ petition, my lord, saying that please consider me in the recruitment process, my lord. Please,
386 days delay.
my lord.
So what did the single judge say?
My lord, what has happened, my lord, in the meantime, the single is, my lord, the order, my lord, is at page 40, my lord. Lord, in the
2016 process he appeared. No?
2014, my lord.
2014 date.
Date, my lord. 2014 date.
Appeared in 2020.
Right.
So he's saying that you have not participated in 2020.
Lord, I was successful in 2016, my lord. 2014, my lord. I'm sorry, my lord. I was successful in 2014, my lord. But, my lord, I could not take steps, my lord. That is why, my lord.
The documents annexed, it appears petitioner participated in 2016. Order impugned. In terms of it has been panel must be deemed to have accepted.
Calcutta.
Then what is your ground?
My ground is that, my lord, I was successful, my lord. My candidate.
In what you were successful?
In the 2014 process, my lord.
Are the 2014 is for date?
Date.
Then what is the RTI you sought?
My lord, RTI sought, my lord, that is at page, my lord, 38, my lord.
whether has passed in an interview held on 10/12. This is which interview? That 16th recruitment process interview.
My lord.
টেট স্কোর এত, মাধ্যমিক এত, total score 12.86. And which category? You are in which category?
General, my lord.
So you were not appointed.
My lord.
So you were not appointed. You did not take any steps. Any instruction you have, Mr. Vishal?
My lord, first of all, my lord, first let my learned friend, my lord, decide in which recruitment process he is questioning. Your lordship kindly see the impugned order. But on the basis of his submission that he appeared in the my lord, the recruitment process 2020. But before that, everything, my lord, before everything, my lord, first your lordship, my lord, your lordship kindly consider page 28 of the stay application. My lord, this is the affidavit affirmed in the writ petition. Your lordship, first line, see the age of the petitioner. My lord, after that, my lord, can we proceed with the, my lord, the further?
My lord, that was when I applied, my lord, 2016. They have considered, my lord.
Prayer A. What is your prayer? Page 25. Your prayer is to fill up the vacancies in notification 23/12/20.
Yes.
Yes.
Then you participated in 2020.
My lord, the honorable single judge says that, but I did not participate, my lord.
Single judge said that you did not participated in. You have not participated.
There is no document to show. You show that document. If you say it is not factually correct, then you show the document that you participate in recruitment process of the year 2020.
Whereas it is found that you participated in 2016.
My lord.
Then what is your case, sir?
My lord, my case is that, my lord, I was successful in the 2016, my lord. And
Where you have written successful in 2016 in your writ petition? Where have you written?
Nothing.
My lord, page, my lord,
But he has jumbled up with the date and the recruitment process.
What happened? Anybody is leading you?
My lord, I will come back after a day, my lord.
আগের দিনই তো টাইম নিল আমার আজকে নেবে
You passed state in 2012.
2012. 14, my lord.
Not 12. 14.
No, 12.
2020 তে পার্টিসিপেট করে থাকলে লিটিগেশনে গাইডেড হয়ে যাচ্ছে। ডিসমিসড। এবার 2016 এ যদি পার্টিসিপেট করে 2016 ইজ আন্ডার চ্যালেঞ্জ। Appointed হয়নি 2016. You have to make clear your stand. If you are 2016 recruitment process after passing TET 2014, that is one story. In an RTI note which shows, it shows you appeared in 2016.
2016, my lord.
Then 2016 you appointed, you made the RTI after 5 years. What is your instruction, Mr. Vishal?
First of all, my lord, is overaged, absolutely. My lord, 50 age. Second of all, my lord,
you ascertain now which he participated in 2020 or not? No.
My lord, I cannot, my lord, unless my lord he gives some documents, my lord, I cannot assist, my lord, your lordship.
RTI says 2016.
My lord, the RTI in regard to 2016, that too, my lord, 2017, your lordship, my lord, knows better than anybody now, my lord.
Now
2016 selection process. My lord, the 17 appointments over, April 17 appointments over. My lord, he made an application 2023. My lord, he gave it reply, my lord, 2023. My lord, we have given, my lord, the details of marks, what he has got in the interview, aptitude test and all at page 38. My lord, even he has not annexed, my lord, what was his query. My lord, he has only annexed the reply of the board at page 33.
Query.
That is, my lord, this is a copy of the board, my lord. This is the answer of the board. My lord, he said application passed in 2006, whether The applicant had passed in, matlab, there is no pass fail. In the selection process, there is no question of pass fail. Whether he was empaneled in his particular district or not, it was given to the website. Definitely he came to know. He's suppressed. Everybody, those who participated, came to know.
So it will have take instruction
My lord.
either you withdraw or we have to pass.
I'll take instructions and come back. My lord.
To be mentioned on 24th November.
Fine.
Yes, next. Yes, item number 8.
I'm praying for adjournment 2 weeks, Lordship. Service has not been done completely.
2 weeks, yes, 9.
হবে না হবে হবে না তো
9 নেই।
For the respondent.
And for the evidence,
check করেছিলাম
I led by Mr. Government Pleader, my lord. Learned Government Pleader is leading me in this matter, my lord. I'm praying for short passover, my lord.
Well, you place the case, you can do the case. If required, we will ask.
শুরু হয়ে গেছে ফোন করেছিলাম
My lord, this is my affidavit.
Oh, there is section 5.
Yes, my lord. There is 67 days delay, my lord.
67. Achha, what is the main matter? Tell us.
State has preferred this appeal against the order passed on 16th May 2025, my lord. Wherein the state has been directed to release and pay the retrial benefit to the writ petitioner, my lord. The state contention is that the appointment of the writ petitioner is not in a sanctioned post. State has not appointed him.
Have you served the college and everybody?
Yes, my lord. Sir.
I'm sorry, my lord.
No, get back your breath. Get back here. Take your seat. Take your. Yes.
We have served everybody, my lord.
Who is this Bidhan Chandra Krishi Vidyalaya? Miss Dina Mojumdar appears.
Yes, my lord.
Yes, she normally appears, my lord. I'm told she was here in the morning.
She was here in the morning. Then inform her to come tomorrow. Or when.
Let it be tomorrow. If it comments.
I don't know, if she.
Mr. Dotto, you ask your junior to give a notice to Lina Mojumdar. We take it up on Wednesday. Next Wednesday.
Very well.
Oh,
she has come. Then, my lord, let me.
You can do the case or any instruction you need.
Yes, ma'am. 67 days.
Wait, there is an application under section 5.
That can be allowed. You main matter.
But the issue involved, in short, whether a project employee,
pardon,
project employee is entitled to get pension from the state bank or from the state government. But the project employee, the project that is AICRP. If your lordship, I'm sorry,
you're not ready, Mr. Dutt?
No, I'm ready. I'm ready, Malad. But Malad, I was coming from another court, Malad. Now, here, Malad, the issue is whether the AICRP.
Let us go through the judgment then.
No, Malad, page 226 is the judgment.
Contempt preferred?
Yes.
Contempt have you preferred?
Contempt. filed the contempt. No?
It's a longish judgment.
Yes. Yes. Malad, here, Malad, the,
What is the wrong in that?
Malad, the
So we have not
logically,
given any approval.
the,
Not taken.
it's, Malad, the AICRP is a Malad project. Malad, I'll have to explain Malad many things. It's a project, Malad, the host university is the Malad, the
Vidhan Chandra
Vidhan
Krishi
Chandra Krishi
Viশ্ববিদ্যালয়.
Vishwavidyalaya.
Did you file opposition before the
No,
report?
there is no chance given to
No.
only report.
Only report was called for, that was filed. And
Two reports, maybe three were filed. One specifically dealing with my allegation that numerous similarly placed candidates were given pension.
আমরা বলছি তো এটা negative mandamus.
No, I'm both. No, my lord, the if your lordship, my lord, takes, my lord, some portion of the improved order and judgment and order. If your lordship takes page 236 once, my lord, this is the improved judgment and order. Lordship, kindly have a look. My lord, the
February মাসে result
page 236, lordship, got it, my lord, paragraph 6, I just space. The project employee, my lord,
pan India information. Public judgment.
sought to brought.
Just give us 2 minutes.
ফান্ডটা বলছি ফান্ডটা এখানে আছে 287 75 25 সেন্ট্রাল গভর্নমেন্ট 75 দেবে পেজ 227 227
That's
in that page 2. Hmm. Expenditure. এটা হচ্ছে আপনার এতে 74 অ্যাক্টে। Provided no sanction. Rider question is provided. Notwithstanding anything longer than university shall not commence or create any create any teaching involving any financial liability. Provide the state government may by an order revise the scale without the state government. এটা তো তাই কন্ট্রোল এক্সপেন্ডিচার অ্যাক্টেও তাই দুটো আছে তো নোটিশ একটা কপি দুজন জজ সাহেবের জন্য
It was done in your presence, Mr. Dotto.
Yes, my lord, there lies the infirmity in my humble submission. My lord, the presence of one of the members, London has proceeded that there lies the infirmity. My lord, I have taken
But
this specific ground.
he alleges that similarly situated persons have been
No,
given.
there is no negative my lord, quality, negative equality. No, I'm sorry. My lord, he claims no negative equality is available. Maybe in some cases, for some reasons I do not know, somebody was given the same benefit. That doesn't mean that should be perpetrated. Supreme Court has deprecated this practice. I'll satisfy Lordship later. Now, my Lord, Lordship kindly sees your Lordship's query. My Lord, the Lord is proceeded on the basis that one member of the government was present in the meeting, and that gives the approval of the, that cannot be termed to be an approval of the government, which is a requirement under the statute. Well, the statute says, if your Lordship allows me, this is part of the, but it's not very legible. That's why.
Mr. Dotto, it is not that he is a recent employee. He had worked in the university for a substantial period of time. Thereafter, attend superannuation. University issued PPO in his favor.
From his own coffers.
Yes, university is in favor of this employee.
Yes.
But Mala Lordship kindly let the university bear the burden. Why that burden is passed on to the government? Because to come into the regular establishment of the university,
on the basis of that PPO pension will be paid. It will be the responsibility of the university.
If your Lordship
is
directs,
the-
but the government funding will not be available.
If the pension payment order is issued by the pension sanctioning authority.
The university has indulged in backdoor entry of a project employee.
Have you taken any coercive steps against the university?
Yes, my lord, the Lordship kindly says yes. My lord, I'm coming. My lord, some fund is released under different heads. My lord, they spend the fund. My lord, on which account, under which head the fund is that the government is normally not given that idea, or they are in remain in dark. supposing my lord 2 crore is released in favor of the university. Now, how this money is spent, that my lord, the government is not aware of it.
The government is reluctant to keep its own accounts. What can be done?
Now, my lord, it's an autonomous body. The university is an autonomous body. My lord, they are what they are doing. This project table, I'll come with other matters. But there is another matter. I'll come with that. They are, my lord, in the morning he is a project employee. In the afternoon he is a university employee. Yes, I have got that document. There is an appeal preferred, more or less of same type. That is pending. That will come before lordship soon, I think. Some Sharma. But lordship.
And PPO sanctioning authority is university.
Well, PPO sanctioning authority is the university. But the university fund comes from the state government. State government says you brought him within the regular establishment without the approval of the government. There is a specific bar under the statute. Control of Expenditure Act as well as
University Act.
University Act. May I just show you, Lordship, how this has been done?
33.
Lordship kindly sees, I just only Malad. I just hand up the two copy there.
Since when he is working there?
33A.
Malad, he is working in the Malad project, mostly in the project. He was a project employee. He continued as a project employee. But Malad, just to Malad, I think after conclusion of the project or at that juncture, he was sought to be brought in the regular establishment of the university.
Mr. Dotto, show us something. He was not the sole engagee. There were other engagees also.
Yes.
As you are saying, negative utility cannot, equality cannot be claimed. We are with you. But unless you can show us that this was project, you are saying it is a project which did not continue. Project. Now, if the project was for a particular period, then also why did you disburse the fund? Now, if you say that
Government did not disburse, the government disbursed the fund in favor of the university. Now,
I'm
the
saying
university.
if the project has expired, if the project is not there.
There are judgments, the lordship knows not. There are judgments, if the project comes to an end, then everything comes to an end.
But in this case, it is not a appointment of yesterday. It is an appointment of 1996. Today we are in 26. You raise no sort of dispute. Now suddenly, yes, what is your stand?
My lord, your lordship kindly come to page 23, 234 of the judgment.
Yes.
Where I have stated, my lord, that the petitioner was given appointment in a sanctioned post, my lord. In a sanctioned post, my lord.
Then what
Paragraph 4, my lord.
What was this project?
No, my lord. Petitioner was given the appointment following the recruitment rules, my lord. Advertisement was made for filling of the post of teaching and non-teaching staff, along with the central administration of the university with the post of ARCP. All the selection process get clapped together, my lord, in one advertisement, my lord. And petitioner was selected.
That advertisement was which year?
My lord, advertisement was made, my lord, in the year. I am telling, my lord.
Ms. Mojumdar, show us that the post, the normal vacancy.
Yes, my lord.
That vacancy in which he was placed.
Yes, my lord. Petitioner was given appointment in a vacant post, sanctioned post, my lord, as a teaching staff. Thereafter, my lord, he was given posted in the ARCP first. Thereafter, my lord, he has transferred to the post of regular teaching staff, my lord. Your lordship kindly come to page 234, paragraph 4, my lord, where I have stated details, my lord. Page 4, my lord. Page 234, paragraph 4, my lord. Fifth line, my lord, where I have stated the recruitment were also made following the provision of the BCKB Act. And my rule 33A is not applicable in this case, my lord. 33A, my lord, is my lord.
Is the appointment letter.
Appointment letter, my lord.
This pursuant to memorandum of understanding at page 45.
Page 59, my lord, appointment letter.
Before that, the memo of understanding is very vital.
You will be whole-time salaried teacher.
Type copy, page 59,
The terms and conditions of service will governed by the provision of BCKB Act. BCKB Act হলে কোথায় follow করেছে terms and conditions?
In appointment letter, terms and condition clause 1, my lord. He will be a whole-time salaried teacher of the Vishwavidyalaya, and he shall normally share his time in at least 2 functions of research, extension, and teaching as to be directed unless otherwise permitted by the Executive Council of the Vishwavidyalaya. Clause 1, my lord, terms and
No,
conditions.
do you take permission from the government before
It
filling
is
up
not
the post?
necessary, my lord. This is the
Not a creation of post.
no.
That is why 33A does
It
not.
does not apply.
So in this case, you must be having documents that these persons were disbursed salaries. These persons whom you have appointed, was the petitioner sole person who was sent to a project work?
No, no. Several person when it is necessary to give appointment to transfer the person concerned to the project thereafter when there is a necessary.
So when his appointment was approved by whom?
Pre-approved sanction post, my lord, by the government. Petitioner was given appointment in a sanction
Where
post.
from we will get that? That is a government approved pre-sanctioned post. Any memorandum to that effect?
My lord. Yes, my lord.
Clause 33A speaks of both creation and appointment. If I may hand up, both creation and appointment.
Career advance scheme দেয়া হয়েছে একটা
33A, you can hand up, my lord.
senior scale applicable vacancy.
But Lordship sees, my lord, consider this 33A.
My lord, page 49, my lord.
No, this project is funded by 75-25 Union of Indian State. We are not, his argument is that he was appointed under that project.
No.
Your contention is that those are to be placed in that project.
Yes.
They were also interviewed.
Yes.
How this distribution? Where is the advertisement? You have to explain to us na, that the government say, suppose when madam you are filling up a sanction post, university must be having documents that this sanction was obtained from the government.
বলেই দিচ্ছে তো টার্মস এন্ড কন্ডিশন উইল বি গভর্নড বাই দ্য প্রভিশন অফ অ্যাপয়েন্টমেন্ট লেটারই বলে দিচ্ছে তো 39 clause 4 অ্যাক্ট অনুযায়ী গভর্ন ম্যান্ডেটরি প্রভিশন
সেই দিকে এখন এই রিটায়ারমেন্ট সব গল্প
একটা কেস খেলে দেওয়া হয়েছে তাই কেরিয়ার অ্যাডভান্স স্কিমে ফেলেছে। হ্যাঁ, অ্যাপয়েন্টমেন্টের পর কোনো প্রজেক্ট হয়ে গেছে সেখানে তাকে পাঠিয়েছিল।
And that is not annexed in this.
Please show us the documents from which Mr. Dotto argues that his engagement was through university. University placed him in a project. Project was funded by state and center. So his appointment was not against any sanctioned vacancy. If you can show us that the advertisement which you publish, it is not that you have directly you have after selection you have sent him to the after selection you have sent him to the project. It is not that he was appointed in the project. First he served as a reader. He is a professor in your university. So you please show us the post-sanctioning memo that must have been under the signature of the competent authority.
Post-sanctioning memo and advertisement.
And advertisement. Yes.
That is
for the scheme and the project. That is for the projects.
Yes. he was placed in a sanctioned post of AICRP. Serial number 11, AICRP on water management. Serial number 11 of that list, my lord.
Yes.
My lords will find, my lord, the sanctioned posts mentioned there.
That is
numbers.
under the project, Mr. Chatterjee. That post is under the project.
Yes.
Your case is not that. Your case is
My
that I
case-
was appointed in a sanctioned post.
These are the sanctioned posts.
This is AICRP sanctioned post.
My lords will kindly appreciate that under the Act, teacher of the university, the definition of teacher makes it clear that he has to conduct research, he has to teach, and also carry out extension programs. What is extension program, my lord? My lord, carrying the benefits of the research to the farmers. These projects, but although state government, my lord, I'll place the definition of teacher, and that is exactly replicated in the appointment letter.
Now you are taking it to an other extent. If we find that the advertisement which was published,
The advertisement could not be placed. His application form is annexed at page 118. Page 118. The application, the advertisement number is referred to here, and also by the university, it's page 118. My lord will find reference to the advertisement number.
The post of lecturer, post of lecturer, agriculture.
Response, your advertiser, university.
The post advertised was lecturer research. My lord is found page 118.
ইউনিভার্সিটি কাস্টাডির মধ্যে নিশ্চয়ই আছে পজিশন অনুযায়ী নাকি
so when were you placed under that project? You were
That my
appointed.
lord will find in the appointment letter. That's the
Which page?
page 117. The typed copy is there, my lord, at page 59. Page 59.
এটা বলবেন ফাংশন পজিশন
For appointment in the rank of lecturer.
Lecturer research. One of the duties, statutory duties of a teacher. This point has been noted even by Supreme Court, my lord, in judgments pertaining to agricultural universities. And then he was placed in as a teacher, and he was expected to teach as well. No, it's not that morning, afternoon, the duty changes. But as part of the Act, my lord, he is also required to teach. Paragraph 22 of the writ petition, page 38, well, it says that he has
Yeah, we
even
have to
my lord,
hear it
guided
finally
research
that-
students.
We have to hear it finally. Today we cannot do so. Your affidavits and everything are on record.
The reports are
Only
exchanged,
report
two
is-
reports. One report specifically dealing with my allegation that even after 2015, as late as 2021,
Now,
similarly,
are you getting any pension now?
nothing.
No,
From
that is noted in the court's order.
nothing. 2020, my retirement. And today we are in 25, 2020. Nothing is being, their pension order, my lord,
Just a moment. Pension payment order is where?
pension order is at page 89. That was issued 4 years after my retirement. All I can do is to, my lord, frame it and keep it with me. My retirement, my lord, the retirement date is mentioned here. 31st January 2021, nearly 5 years ago.
ইউনিভার্সিটিতে
ইউনিভার্সিটি কবে পাঠানো হলো
And my learned senior friend is my lord, alleging negative equality. Supreme Court has said that if similarly placed teachers are getting pension, even the petitioner cannot be discriminated. A coordinate bench of this court has passed a judgment on that scope in respect of another project.
All your approval, your continuance, all are by the university. Please show us some document.
If the statute empowers the university to
That
first
is a
to
different stand altogether.
so
We are
the
not wanting to know that. We are wanting to see your initial entry. Prima facie, you are satisfied that you were not appointed under a project. You were appointed at an independent post as a lecturer.
pursuant to a regular selection procedure.
Right. So if Miss Mojumdar can show us that the posts of lecturer which were filled up pursuant to such advertisement had a sanction of the government, then I think Mr. Dotto will be in difficulty. স্যাংশন পোস্টে করতে গেলে তো ওদেরকে একটা রেজলিউশন যে গভর্নমেন্ট আমাদের এতগুলি পোস্ট লেকচারের পোস্ট ফিল আপ করতে দিয়ে দিয়েছে, some resolution will be there or some record will be there to show that the post of lecturer which you have filled up, Mr. Chatterjee says he was applied as lecturer, appointed as lecturer. So if the lecturer post, that is a post which has to be sanctioned. It is not a creation of a post, it's a sanctioned post.
But
if you can show us the resolution which is required.
But the approval must come, as my lords correctly say, it must come from the Executive Council. The Vice Chancellor cannot issue an appointment letter to a teaching staff.
Exactly, Mr. Chatterjee. So we are wanting to know, before an advertisement is published, there has to be an Executive Council meeting of the university discussing that we have 5 posts vacant, we are going to notify this. And in Executive Council meeting, there is a government representative.
But is it not too late in the day to take these pleas after having?
Is another aspect, because he is raising a point which goes to the root of the matter.
Yes,
If we
there
can
are
find,
matters similarly.
we can find that it is a sanction post, question of interference with the order does not arise.
I say at least I can show from the records that the post of AICRP was sanctioned.
We are not with Mr. Chatterjee. What we are wanting to know is your initial engagement was not in AICRP. AICRP is a project what mutual.
I was placed there. And when I had applied pursuant to the advertisement,
you were there for some time in the project work. Thereafter, there was no discontinuation. You came back to the university. They promoted you. They gave you career advancement scheme. So those points are in support of yours. And if we have a question, we are entitled to
of
seek
course,
an
most
answer.
certainly so. Malad, I bow down. But as a teacher, the teacher is
Madam, you
helpless.
please, I don't know whether this advertisement, 96 advertisement, whether you will get.
It is available or
All
not.
the students are
Implement a
occupying-
copy of resolution whether the post is sanctioned
Yes.
by the government.
Whether the only a document to show those arguments that negative equality will not come if we find that the question, there are two forms of appointment is you are a university, you are funded by the state. Mr. Dotto takes upon, I give the grant, how the university spends, I am not concerned. Anyway, so that is why there is a government nomination in Executive Council, so that the university cannot take any step which is contrary to the government norms.
And where he is placed is not within his control also. He has to go there. And he has to come, he may come back again.
Hard Mr. Dotto learned government pleaded
Report is normally
But
not supplied.
the crux of the report is there.
Report is supplied, give furnished to the court, not to the other parties normally.
You don't have a copy?
That's it.
হ্যাঁ
Now it is coming from
তাহলে
Mr.
Miss
Chatterjee, not
Mojumdar
from
learned
Ms.
advocate
Mojumdar.
appearing for BJP
It's understood that contempt proceedings.
Contempt proceedings is very difficult, Manoj.
Contempt proceedings, they should
Justice
not pursue.
Tendulkar's court is so crowded, I can't even enter to mention
But
it.
let that be recorded at least, that he
So
cannot.
then we record it, Mr. Chatterjee submits
cannot-
that he had not been able to
Not been able to enter that courtroom for mentioning.
For pursuing the contempt proceedings.
Considering such inability, we restrained ourselves from passing any interim order.
Inability.
So let there be at least one line, Manoj, so
No,
that
no, no,
let
no
there be
line.
no technical difficulty
Then
later
this
on.
December will become 26.
We pass that order on that day.
After
Well,
third
that's the
December.
After,
report of the
is there any
appeal on that day.
possibility?
I don't know, it is for them to say, I can't say.
After
So it
3rd
is their,
December.
it is their proceedings. Appeal is placed for hearing normally, Maladi.
So shall not make any effort to enter into that court.
Yes,
The
let that be
determination may
recorded.
change.
Mr. Chatterjee assures us who is there?
My lord, I appear for the respondent, my lord. We were permitted to use an affidavit
I appear for the appellant.
to one of the, my lord, applications, GA2, which is an Order 41, Rule 27 application.
We will hear it
Along with it. My lord, my affidavit is ready, but I have not yet been served with a reply.
Your lordship will give us 2 more weeks to file the affidavit in reply, your lordship, and thereafter we'll come.
My lord, last resort. লাগবে order? My lord, they are challenging an order passed, my lord, in an execution proceeding. There is already a suit subsequent to this which has been filed claiming, my lord, self-same release. We are saying, my lord, it's already, my lord, the issue has been decided. There's nothing, my lord, left in this appeal to be decided. That's our contention.
GA2 is order 41.
That's Mr. Ghosh's order 41 rule 27 application. তোমরা reply affidavit extension নিলে 2 সপ্তাহ।
And the only thing with the reply was, Manoj, I thought it will be just a reply to 47, but my learned friend had taken leave to take all additional points. So when I settled the reply, I said this is too long, and I made it really short. And then I saw the order that he has been given liberty to take all his points.
The order permitted us to disclose additional documents also, whatever we wanted to.
So I was, so I'll need to reconsider that document.
Well, this is my appeal from a decree setting aside and recalling the compromise decree already entered into by the parties in a suit.
Yes, ma'am. Led by Mr. Galib.
Yes.
Upon 11, any problem? 11.
After then Lordship in the month of January.
I'm the plaintiff in the suit. This is yes.
Let's do it now. I have no difficulty.
আমি তো আমি কি
It's a date, January 1st.
not in December my lord.
December, the problem is it may become a only listing matter.
Not a
Applications will be on 25th, I think.
yes.
It is
25th.
24th is the last.
24th is the last.
40 days. আচ্ছা তুমি আজকে দাও তুমি। Dr. Patru,
On behalf of Dr. Patto, I am praying not today. With the consent of Mr. Ekramul Bari, my lord, I am praying only not today.
next Thursday, 20th. Yes. After the
Same prayer, my lord.
The same prayer means 13 is not the count.
11.
Oh, 12 prayer.
Yes, my lord.
11 respondent and 10 হচ্ছে appellate.
Yes.
তো ওই আগেরটা ওই আইটেম নাম্বার 11 and 12.
Yes, my lord.
11
10, 11, 12.
10, 11, 12 17 তারিখ করে দাও 17 না না কবে করেছে
Next Thursday.
20th না 24th করে দাও yes next
It's 24.
14
24.
Will I appear for the petition?
I am for the respondent number 11 and 12, my lord.
private respondent
Private respondent.
state you have served service complete
Yes, yes. Elaborate certificate.
This affidavit of service, man. Appellant hearing, my lord. Petitioner appellant before your lordship, this is my affidavit of service.
ordered in which page
Yes, my lord. Lordship will kindly takes, my lord.
108
Yes.
give us 5 minutes
Yes, yes. My prayer is very
108.
What?
you are the managing committee
I am for the president and my lord,
is the managing committee a party before us
yes, yes. My lord,
you are the president of the present functioning managing
yes,
committee
yes, yes.
so you want to take steps against 11 and 12
My lord, Ajit Kumar Mahato 12 and 13. Prashanto Singh.
why did you come before us
No, my lord, what has happened? My lord, this is, my lord, I should be, my lord, very.
11 12 ex-president is 11 and
No, my
One
ex-president.
ex-president and one head.
Headmaster is the main person, my lord. What has happened? My lord, your lordship has gone through it, my lord.
headmaster has superannuated
Superannuated, my lord. He has
Wait.
lost 2021.
Lordship will kindly takes my lord my representation first on page 17, page 36.
Page 36.
Yes.
This question. Okay.
2021 he retired.
Yes.
So why did you issue no due certificate in his favor?
Yes, because that was done by the earlier president. It was in connivance with the
তাহলে তো চলে গেল আর কি করে?
Now, what is the problem today?
ডিউ সার্টিফিকেট ইস্যুড, পেনশন স্যাংশন সেটেলড, আর কি হবে?
That is I'm before your lordship.
আবার বলে আই বি।
No, today the situation is very bad. Your lordship will kindly see page 36,
Place it.
This is to inform you that I, Prashanto Singh Mahapatra, has assumed the charge of teacher in charge of Benla C. RN High School due to the retirement of the headmaster Sri Ajit Kumar Mahato. But unfortunately, I have not given any documents related to the both boys and ashram girls hostel at the time of charge handover. Please do the needful, otherwise I will not be liable to anything concerned with these two hostels. Now, my lordship will kindly see after
But the
that.
teacher in charge. You were the teacher in charge. So you represented before the project officer come.
Each and every series of representation. Lordship will kindly see page 37. After that, I have read.
What is your legal right, sir?
Today, what has happened? DI. I have made a representation at page 44 before the DI. Lordship will kindly see page 44.
44.
Yes. This is to inform you that I have assumed the charge in teacher in charge of Belma C. RN High School due to superannuation of headmaster Sri Ajit Kumar Mahato. But unfortunately, I have not been handed over some of the important documents of the school by the ex-headmaster mentioned as per your telephone. I have once again requested him in writing hand over those documents, but no response has come from his end. The copy of the letter
After his retirement, you were appointed.
I have been appointed, my lord. Now, the most problematic thing is that, my lord, if your lordship sees the resolutions which have been passed, there are serious, the service records are also missing. The entire thing is missing. I don't have. Yes, lordship will kindly see, my lord. At page 46, lordship will kindly see there was a resolution by all the members. Now, my lord, relevant part, if I read for your lordship, my lord, page 47. First. Page 47, it's written in vernacular, my lord. অদ্য সভায় প্রাক্তন প্রধান শিক্ষক শ্রী অজিত কুমার মাহাতো মহাশয় কর্তৃক বিদ্যালয়ের বেশ কিছু গুরুত্বপূর্ণ কাগজপত্র না দিয়ে এবং আয়ে ব্যয়ের হিসেব না দিয়ে তথা কোনো অফিসিয়াল চার্জ হ্যান্ডওভার না করেই পালিয়ে যাওয়া ও তার এই পালায়ন বিদ্যালয়ের ম্যানেজমেন্ট কমিটির সভাপতি শ্রী ধীরেন মাহাতো সাহায্য সহযোগিতা করার বিষয়টি অত্যন্ত গুরুত্ব সহকারে আলোচিত হয়। প্রকাশ থাকে যে গত 31 মার্চ 2021 তারিখে বিদ্যালয়ের প্রাক্তন প্রধান শিক্ষক শ্রী অজিত কুমার মাহাতো অবসর গ্রহণ করেন এবং তার অবর্তমানে বিদ্যালয়ের যাবতীয় কাজকর্ম পরিচালনার জন্য গত 8 মার্চ 2021 তারিখে স্টাফ কাউন্সিলের বৈঠকে সজ্জায় বিদ্যালয়ের সব শিক্ষক শ্রী প্রশান্ত সিনহা মহাপাত্রের নামটি মনোনীয় হয় সর্বসম্মতিক্রমে। কিন্তু প্রাক্তন প্রধান শিক্ষক শ্রী অজিত কুমার মাহাতো ভারপ্রাপ্ত প্রধান শিক্ষক টিআইসি কে অফিসিয়াল চার্জ হ্যান্ডওভার না করেই বিদ্যালয়ের অতি গুরুত্বপূর্ণ কাগজপত্র ও বিদ্যালয়ের টাকা পয়সা নিয়ে পালিয়ে যান। কাগজপত্রের মধ্যে উল্লেখযোগ্য হলো স্কুল ডিড, স্কুল রিকগনিশন, টিচার্স রেকর্ড, টিচার্স সার্ভিস বুক, টিচার্স পিএফ লেজার, পিএফ উইথড্রল মেমো, ক্যাশ বুক, সাপোর্টিং ভাউচার্স, ক্যাশ বুক, ভ্যাকেন্সি স্টেটমেন্ট, ইম্পর্টেন্ট রেজলিউশনস প্রভৃতি। এত সত্ত্বে সব অজিত বাবু টিআইসি কে সবকিছু বুঝে নিয়েছে বলে লিখে দিতে চাপ প্রদান করেন। এক্ষেত্রে তিনি ডিআই অফিসারের ক্লার্ক শ্রী জীবনদার মহোদয় ডিআই মহাদেবের সাহায্যে নেন। অজিত বাবুর এই চাপের কাছে নথি স্বীকার করে না করলে what Lordship knows much better than us, what is the outcome of that? What is the
But
outcome
sir,
of that?
how can we allow you?
Now, may I pray before your Lordship?
Now you want us to
The
send
DI
it
is
to PI.
sitting since last 4 years.
এটাই তো তাহলে
Now, if your Lordship direct them to file an affidavit at least, my lord. Why they are not disclosing the documents? Why not? What they
why they are not disclosing? They will say that I have no document. I have handed
No,
over.
that is a resolution has been passed against it.
Resolution was in after 2 years, sir. 2 years you are making this resolution.
Even 22.
That all these
Yes.
your resolution date is 16th June 2020.
You are the headmaster. You are headmaster.
Headmaster and ex-headmaster, ex-president.
Do you have any papers?
Have you handed over the charge?
Yes, my lord. Lordship may kindly hear
To whom?
to the president because my lord, he retired in COVID period. Lordship may kindly consider this. He handed over all the documents to the president, and my lord, Lordship may kindly see one thing. He
To the
retired in 2021, 31st March 2021. This president has taken over charge on 9/12/2023. 9/12/2023. He is saying all the papers are not in the custody of the school. It's lying with the ex-headmaster.
No, he is the teacher in charge.
No, he is not teacher in charge. He is president of the school. President of the managing committee. Teacher in charge is not the petitioner. School is the petitioner. Lordship may kindly see who are the petitioners. School not represented by anybody. Then petitioner number 2, president. My lord, first petitioner number 1, only the
School is the appellant.
school, only school, not represented by
No.
headmaster.
School and then after that president is there.
My lord, আমাকে বলতে দাও। School is the petitioner number 1. School is the petitioner number 1, not represented by headmaster or anything, only school. Only school. Then
President is a party.
president is the petitioner of the managing committee, no resolution of the president of the managing committee is the petitioner number 2. Lordship may kindly hear me. If I may be wrong, my lord, there is no resolution annexed here where the managing committee has authorized the president to move this on behalf of school.
When did you retire?
I retired in 31st March 2021.
So you have handed over charge to the then president.
Yes, my lord.
What was his name?
Hiren Mahato.
So this
Dhiraj Mahato, sorry.
no due certificate was issued in your favor. Must be.
Yes, no liability certificate from coordinator,
Yeah, no
from
liability certificate.
project officer, from everywhere, from
Why
everywhere.
project? Who is the why project officer?
Because this is within scheduled caste area, my lord, some ashram hostel and
No
its
liability was issued by the school authority.
school authority, no liability by the coordinator, my lord, that project officer. Everything is okay, my lord. Only out of personal grudge, if it is done after 2 years, my lord, when there is allegation against my client for defalcation of money for taking all the important documents, though the school is running without all other important documents. It's not believable. Anyway, my lord, they have not lodged any complaint before the police. My lord, now in 2024, filing a writ petition, there,
Page 71 is the only
my lord, who is,
certificate obtained by from Dhiraj Mahato in favor of the ex teacher in charge.
my lord, the present headmaster is not party in the matter.
Sir, school to party আছে
School তো আছে তো কি আছে?
let her file an affidavit, madam.
Head of the institution is not made party.
We will take criminal steps.
Where is the resolution empowering the president?
Yes, it is there.
Yes. Well, police complaint has been filed, my lord, at page 98.
That you have 98 is to the DI. Acha, what is missing? What he has taken away?
Entire thing that has been.
Don't make vague statements. 47. they have your allegation পালিয়ে যান কাগজপত্র উল্লেখযোগ্য হলো
school deed,
school where is the police complaint?
the police complaint at page. It has been filed, my lord. Page 80, 98. Page 100.
This was lodged in February 24.
Yes. Why, we are waiting.
Why any police case was registered?
Nothing. Nothing has been registered.
So very good, you proceed with that.
May I ask?
He will say that. He will say.
May I pray before your lordship, my lord? As the ex-teacher is appearing before your lordship, my lord, but later file an affidavit to that effect, my lord. What charges he has given and what documents he has filed. But let her come, my lord, we will come back. This is what he is filing an affidavit before this honorable court.
Page 47.
Yes, my lord.
The then secretary, he handed over everything to the then secretary.
Not secretary, my lord,
The then president. The then president issued a document declaring that I have received everything from him.
Yes.
Now, president also received such same declaration from two clerks, that all these two clerks got everything.
Yes, these two clerks.
ম্যানেজিং কমিটি সভাপতিকে দিয়ে সবকিছু বুঝে এই মর্মে একটা ডিক্লারেশনে সই করে নেন। এছাড়া টিআইসি কে জানিয়ে ম্যানেজিং কমিটি দিয়ে নেয়। ম্যানেজিং কমিটির সভাপতি দিয়ে বিদ্যালয়ের 2 জন ক্লার্ক তথা সাধারণ সাজ দিয়ে সবকিছু বুঝে ফেলেছি বলে সই করিয়ে নেয়। Therefore, your then president before the erstwhile headmaster, there are one declaration that your then secretary issued a declaration declaring that I have received all the valuable documents which he had with him at the time of his death.
Now, may I pray before your lordship, my lord? But this is a serious, why I am saying, because the school is suffering. Now, let him put an affidavit to that matter. I'll not ask any prayer before your lordship. But let him come with an affidavit that he has handed over the charge in respect to what he has handed over and what is the status. Kindly, let him file an affidavit. He is getting a pension.
Come to page 109. If the petitioners are agreed by the actions of the Rational 11 to leave is granted to them to take steps in accordance.
That your lordship knows much better than us, my lord. What is
But
the
for that you are.
I am the last person to argue on this point, my lord. I am only praying before you. Kindly, this is the matter, my lord. Why I have filed an affidavit, my lord.
We have heard you, sir.
Let her file an affidavit to that, matter. Let her file an affidavit that she has discharged every duty as per the service records is concerned. Everything has been done, my lord. Let her file, man. But let her file. Let her
So
come.
a person will retire You will issue no objection certificate, everything.
Who has?
Fee
Well,
after
who has?
whoever is that in
Well, today,
proceeding, you
Lordship,
proceed is the
Lordship will kindly cease, my lord. Lordship will kindly cease.
present
Well, a
appeal.
resolution has been passed.
I come with a good case. The present appeal has been preferred, challenging an order
I don't know, 14 and
Ashukan, Mr.
My lord, item number 14, Mr. Sudipto Manda appearing for the state, my lord. I am paying for not today. He is on leg before court room number 37.
সবাই লিখছে
kindly fix this matter after 17th because advocate Bhuglubamar is appearing this matter. He is right now in Bangalore on Alia version. Your lordship also fix this matter after 2 weeks.
2 weeks. তাহলে tell us now when he will return.
I mean, after 17th any day.
That day also you said that after 7 days kindly keep.
Yes, ma'am, he will be back by this week.
So why did you ask for 7 days? Just because we are being lenient.
My lord,
Don't do these. These sends bad signals.
kindly fix this matter.
We act on believing the advocate. If the advocate says something, we feel sad because there are matters. Unnecessarily, these matters are listed. When you are minded to take adjournment, unnecessary. Go before anybody, dismiss for default, gone, finished.
My lord, kindly
We don't do that. As we don't do that, you take advantage.
No, my lord, kindly.
2 weeks করে দাও।
14 and 15, my lord, same.
15 I appeal for the state.
I am for
But
second
there-
board.
14, 15, 2 weeks. Yes.
Hold on. Hold on.
Item number 16, I am appearing for.
Lord, I am appearing for the college authority. My
Lordship,
lord,
on the- Lordship, on the last occasion, Lordship directed upon me, that is petitioner, to serve the copy of the stay applications to the Calcutta University. Lordship, I have served. Now it is upon the direction of the respondent number 227 to file the reply. I mean, they have vehement objections on my submissions as well as on the stay application itself.
Let us see the order.
Lordship.
Lord, I am appearing for the.
They have filed the opposition.
No,
My
Lordship.
Yes.
My lord, I am appearing for the respondent number 227, my lord, led by Mr. Subhrang Sumanda, my lord. My lord, we are not ready, my lord, affidavit opposition. My lord, not ready, my lord. Kindly needed another 2 weeks time, my lord.
Not
Opposition not ready, my lord.
What is the matter about?
Yes, Lordship, I'm submitting that is that order dated 16th May 2023, passed by the single judge of this honorable court. I'm challenging that order because I have different kind of position, but not recognizing a post in particular this university.
It is in the adjacent building.
Lordship,
Then-
Lordship, it's not actually Lordship, the post. The post which I'm holding at the first time, I mean the first appointment letter, which is in page number 30, it was, I was first time appointed as an assistant to accountant. My post in that university, that is Shamaprasad College, was an assistant to accountant. And after that, Lordship, my post was not cleared by the university. Day by day, they are changing without giving me a single penny extra. They are making me walking over their institution without sanctioning any post. But I am appointed by the Calcutta University Act 1979 Act. The Lordship was put me.
Why you are not getting your salary?
Lordship, on that note, I am getting salary very minimal. But salary, Lordship, I'm getting.
Your appointment letter.
Lordship, my appointment letter is in page number
21,
30,
29.
page number 30, Lordship.
Have been appointed.
Confirmed your service. No, this is confirmation.
Lordship.
Very
29, 29.
full-time assistant
Presentation.
appointed as a full-time assistant to accountant
Order,
on probation.
transfer order.
I'm sorry,
Appointment letter, Lordship, page number 29.
yes, very good. Then what happened?
Now, Lordship, when my appointment has made, and after that, I was working on that particular post.
Hmm.
After that, in page number 30, the governing body, actually, Lordship, I am appointed by the GB. Precedence and rule is governed by me. My post is there for permanent post, and that is that my service letter is page number 30. I was appointed. That is page number 29, and 30, that is page
How
number.
much salary are you getting?
Lordship,
This is not a assistant. You were given an additional duty.
Lordship, they are allotting me additional duty, but they are not paying. Actually, my post was assistant to accountant.
For evidence, why you are not coming out with that?
Now, Lordship, in the writ petition was going on, actually the rule is in every month of July, my increment will be there. Everyone is getting increment. I only get 3 rupees increment. And Lordship, in the month of October, November, December, I don't get my salary even. And now, when this appeal, this stay application is pending before this honorable court, they are barring me to write my signature over the register. Lordship, this kind of harassment I am facing. I went to them. I beg that please.
Where is the document? How much salary you are receiving? Where is your pay slip?
Lordship, page number 29. That is 12,000 per month.
Where is your pay slip?
Lordship, pay slip is not annexed, but Lordship, in my
Bring your pay slip.
Lordship.
You are not play. If you are getting salary, you show us the pay slip that you are in a confirmed post.
Lordship, in my reply, I will annex that and I will submit, Lordship.
Hard Miss চক্রবর্তী, Miss Lanet Advocate, শুধু
My lord, I appeal to the petition. My lord, I think the matter will be released because my lord Justice Chatterjee's order has been challenged.
the order impugned in the present appeal has been matter. Rupam.
I've served. I think the
Appeared earlier.
maybe the other service, maybe with the file, because I have the photocopy of the same. আগে originalটা কোথায়?
Oh, it appeared before another bench. Mr. Banerjee, give a further notice.
Yeah, that's for fresh notice also given
No,
the
no,
other
that-
day prior to listing the matter.
Who is your other side?
Joydeep Banerjee, and another was there. I've also served the school also.
File an affidavit of service to that effect and tell them to give a ring to them. It is a different bench, na? So
I follow what's for
Monday.
Monday. Not sure, please.
PS next.
I am for the writ petitioner response.
Well, I am for the applicant, my lord.
Yes.
Extortion application along with 6 and 5.
Uh-huh.
Extortion application along with 6 and 5. 5 days delay.
Restoration with section.
Dismiss.
What is the main matter?
My lord.
Main matter ta ki?
My lord, this is a approving the organizing staff.
No, just oh.
My lord, since 1995 onwards, I am not receiving the pension. 1995. They filed this appeal in 2015. Since 2015, the matter is never moved. All of a sudden, matter came up before His Lordship, the Honorable Justice Rajashekhar Mantha, and since none appeared, appeal was dismissed. And contempt is tomorrow. Contempt was fixed for compliance of the order of the learned trial judge. Tomorrow, this is the order. Tomorrow fixed.
So, please come to the main. Place the main matter. What is the
Kindly see the page.
The application has not been served upon us. Only section 5 and I am ready with the matter. I am ready.
No. What did you do after 2014?
My lord.
What did you do after?
My lord, contempt is running in the list.
Application is
2014.
2014. Even my lord, kindly see the last order. They are every time they are taking the time for compliance, and this is the last order. Tomorrow is fixed for further compliance and personal appearance. Tomorrow fixed. And thereafter, my lord, this restoration application.
No. Before that, I filed the restoration application.
Order was also ex parte. That they did not.
Order was already ex parte, my lord. Page 99.
Page 99. Page 99.
99. Of the state petition, my lord, page 99.
We do not have the stay application. Stay has not been served.
Lawyer change হয়েছে না কোথায় কি হয়েছে কেউ জানে এই বাই পোস্টে করেছে রিটার্ন এসে দ্যাট ডেলিভারি রেজিস্ট্রেশন নোট স্টে পিটিশন এটা তো রেজিস্ট্রেশনের মজা করেছিস
আগে
গল্প করছিস আর গৌরব তো দিয়ে এসটি আরেকদিন রুইছে তো ওরা অফিসে মিটিং সেন্টারে অপেক্ষা
না আমি প্রথমেই করি, আমি কোনোদিন করি না।
ডিপার্টমেন্টের কাজ করেছিস তো নাইনটি নাইনটা দেখি দেখি যে অর্ডার দিয়েছে তারই জিনিস অর্ডার আমি বলেছি লিটিগেশন জানিস না মনে হচ্ছে
হ্যাঁ, that has been considered.
পয়েন্টে যাবো
ঠিক আছে।
They did not take steps.
My lord,
How can we-
2015, the contempt was, my lord, kindly see, I have handed over the copy.
Should have taken appropriate steps.
My lord, we have taken an appropriate
What
step.
steps?
Every time they are come with an plea that kindly
Then you should have come up in appeal against that. What now? What is to be done? Person is not there. He has retired.
well, at the time of
The
passing that order,
trial
he was
court
already.
says, trial court says that you give him pension. On what basis? Then I have to absorb. You have to pass an order of approval. Government cannot, once it is
My lord.
directed pension to be given, it has to be construed that he has discharged 10 years of service.
My lord, kindly ask them to produce
Mr. Chattopadhyay, in one
DLIT
case,
report.
in one case, what happened? Mr. Sen, additional advocate general, appeal. There, this sort of a provision was there, and state also did not listen. I said, give some money to the person. Mr. Chattopadhyay, why don't you settle this? Give some money, finished. Because state.
Organizer teacher, they have any right without sanction post, they are working. The same judge at the division bench, what observe I produce.
No, here the case was absorption could not be made because there were the vacancies were inadequate. Single judge found that no, this statement is wrong because there were 2 additional sanction posts.
Additional sanction post that has been created due to that not person. Because after continuation of the school, the strength, the additional post has been created. It is not for him. In DLIT, my lord,
It is a model employer, order pass communicated, read
what
of
this, my lord,
2008.
at this stage, my lord, Supreme Court has taken the several decision, my lord, and also, my lord,
those arguments will advance. Supreme Court ei boleche, sei boleche.
and not only that, my lord, our division bench, my lord, this
I have delivered a judgment saying this sort of practice on the part of the state is it is very unexpected. The model employers from the state of model employer can, I deducted payment of compensation of 10 lakhs. Same thing, rotating. Talk with your secretary, give some money, finish it off.
that is up to Lordship, my lord, I cannot. Because according to law, my lord, and nothing to say, your Lordship, on the basis of the sympathy or whatever may be.
No, I am not being sympathetic. I am saying there had been latches on your part. If you want to contest, we will suddenly consider it.
My lord, 2 things is there. My lord, 2 things.
কোয়ালিফাইং সার্ভিস 10 বছর না হলে তো কিছুই পাবে না। অ্যাপয়েন্টমেন্ট করতে হবে। Where do we get that on the date of DLIT there
I am
were
present.
8 vacancies? Where from do we get?
My lord, it's come, my lord, to the notification of last, my lord, since the stay application has not been served upon us. However,
stay.
My lord, only section 5 and restoration application has been. My lord, since my lord, kindly see the last order of remand. If your lordship is available in the stay application, I have the order of contempt.
Stay application serve kore.
Well, several times lawyers have been changed. So it is our duty to communicate the petitioner, but that has not been done by my clerk. Several lawyers have been changed, my lord.
My lord, now the point of my lord organizing.
DLIT reports everything.
Yes, I have.
What is the point you are saying?
My lord, now, my lord knows that from the Monindra Chandra Sinha Sritikona, that has been the practice of the organizer teacher has been stopped by the division bench of our court. Now the latest rules and latest law is a Niranjan Shahu, passed by Justice I.P. Mukherjee, where it is specifically stated that at the date of inspection, if the person is present and its name has been features from the DLIT report, and subsequently if
your DLIT report is there.
Yes, my name is there.
Very good. Now your name was serial number. Where is the DLIT? Your writ petition is not here, Mr. Das.
My lord, I have the copy, my lord. If your lordship kindly gone through my
page 46. Yes. DLIT, your name was there.
Yes. Page 36. I have only this copy of the writ application.
We have. Keep it with you.
Page 36.
No. The page 47.
My lord got it. Page.
Your name is
Page 36. Your lordship got it.
Yeah.
Now, my lord, kindly.
Your name is Mohan.
My lord, page 40.
40 of your writ petition.
Writ petition, my lord. My lord, this
particular of the member of
the
40 serial number 4.
You are not getting it. Like to thou the tutor.
My lord, excuse me, my lord, I am marking.
Fourth. Date of appointment 84. Then? No, their stand was there were no adequate posts.
My lord, if your lordship kindly come the impugn order. Before that, my lord, when the demand was given, my lord, that is page.
You give the stay application to him. How will he argue?
Yes, I do not know that has not been started.
But we cannot give you any protection. Tomorrow, what the court does.
Tomorrow? Tomorrow I will be absent. I'm partner difficult.
No. We are keeping it next week.
Yes.
Give the copy.
Yes.
We will not grant stay at this stage.
No, section 5?
Section 5, आगे तो satisfy करो. Merits, on merits we will hear. No section.
I'm just handing over. Okay.
Very deplorable acts. Very sad situation.
My learned senior friend is there.
Fight with him before that court. Tell him that give some compensation.
Not compensation. He is minded to grant everything.
So very good. Very good. That is so very good.
Supreme Court uncle.
Then tell us when do we keep it?
Not any day. I am ready.
Then you do one thing. We are keeping it on 25th. If you want to use any opposition, no, dorkar nahi. Section 5 is there. You bring the record.
If your lordship restore his restoration, then your lordship has to hear the section 5. In main matter, there is a section 5.
Oh, main.
My lord, kindly see the conduct. 2015, the appeal was filed. Stay application filed in 2018. There is a section 5 application. If your lordship is restored, and each and every time they come with a plea that kindly give it.
এটা কিন্তু
In preparing the appeal.
In preferring the appeal, what was the delay?
Not served.
Huh?
Only served restoration and section 5 of this.
Yes, Mr. Chattopadhyay, what is the, then you argue on section 5. Where is your section 5, Mr.
68 days.
Both 68 days.
But then I used an affidavit.
468.
406.
486.
And restoration?
Restoration 5 days.
5 days only.
Now restoration 5 days after dismissal, recent dismissal. But main appeal there is a 400.
Well, your lordship kindly aware that in fact, whatever the appeal has been dismissed.
Which one? Which one?
Justice Mishra, then Chief Justice.
Yes.
Every appeal has been taken without any stamp report or report dismissed.
তো তা যে আমাদের ধরছে কেন কি আসছে
So earlier courts, after going through the in several courts, after going through that order,
Mr.
allow.
Chattopadhyay, get yourself ready in section 5. We will catch you on section 5. If you do not succeed, go and comply. Yeah. 468 days delay. In fact, situation like this, which is your application section 5? Can number?
আছে তোর কাছে কিছু
This restoration.
ক্যান নাম্বার কই?
Where is the restoration application, sir?
Not been served.
আর দেবো দাঁড়া না বাবা একসঙ্গে ঘাটিয়ে দিস না। ও তো চেঞ্জ হয়ে
Many matters, my lord, I am
Can
assisting this.
4543 is a application for condonation of delay in appeal.
Appeal.
Preparing the appeal.
This in the here there is a delay of 468 days. 468 days. আচ্ছা।
আর এখানে সেকশন 5 হচ্ছে ক্যান 4.
Stay is already
দিয়ে দেবো আমাদের কাছে আছে তো
আচ্ছা, give the copy, come back on when you are not there on which day?
না লর্ডশিপ
19 is
Tell us.
মানে only total hearing or section 5?
Total hearing.
হ্যাঁ,
First, so you will acha you satisfy section 5 first. Hearing on section 5.
next Thursday.
বলুন,
Next Thursday.
to be mentioned Thursday. Regular.
বুঝে গেছি।
You won't be there.
হ্যাঁ?
You won't be there on Thursday.
No, I will not. Monday and Tuesday I will not be able.
কিছু দেওয়া নেই। Since division bench is ceasing over the matter, kindly adjourn. I request your lordship not to pass any order today.
Mr. Chattopadhyay, you have not completed service. What order can we pass? We are keeping it to be mentioned on Thursday. That we
Grateful.
Sure, take it.
Bro, এতভাবে গলা টিপে মারছিস তো? খুব গলা টিপে মারছিস।
অ্যাপ্লিকেশনটা জেরক্স করে দিয়ে
Anything?
Well, can it be taken up next week?
Bullshit. What is the joint prayer to allow the appeal?
Can it be taken up next week, my lord?
No, Mr. Prasad cannot.
No, he is supporting my prayer also.
He's supporting.
Because
No,
my
no.
lord, the exceptional situation, because my mother, there was a operation, my lord, on my mother, because there was a fracture.
He's all right.
She is recovering.
Item 21.
He also. What do you want?
Kindly take it up on next Thursday.
Next.
I have also the CAN application in connection to this matter.
In
item number 21.
Where is your
Next
Thursday.
Thursday.
Next Thursday, Your Worship, thank you.
Next.
If